So yeah, that's all. And I'm sure when we get you up on the stand, you might get some further admonishments from the commissioner or her staff on how to get situated properly. But that's the biggest part of it. You'll just sit here, talk on the microphone, and then we'll look at this screen here whenever we put up an exhibit.
Okay. And you're welcome to try it out if you like.
Want to have a seat?
And you're welcome to have water or anything else you like up there.
Okay. Thank you.
You're welcome.
Okay.
And that's where I talk. Okay.
Yep. You sound perfect. I can hear you clearly.
Is that too close or?
No, I think that's fine.
Okay.
Thank you.
Okay. Yeah, it'll just be that simple. Okay.
They showed us that. Yeah, they did show us.
Yes, ma'am. You bet.
She'll help us out. And this is for anybody to use?
Yes, sir.
All right, thank you.
You're welcome.
And is this where the jury sits?
The jury will be seated here. And in fact, when they come in today, there'll be more than 12 people here. There'll be probably 20 to 30 people here. And the first, I guess the first 9 we get, that I think we're doing a panel of 7 plus 2 alternates.
8. We're going to do 8 and 2.
8 and 2.
Yes, sir.
I'm sorry. So the first 10 that we get that qualify, we'll seat those, and then the rest of the potential jurors will leave the room when we have our jury set. Okay? And then after we get the jury set, the judge is going to have some instructions to read the jury. And we'll start that from there. Okay?
I hope I got it all straight.
You did. And how'd you get through security? Did that go okay?
Oh, yes. Uh-huh.
Good. Good. And you found it your way up here okay?
Oh, yes. I just
Excellent.
took the elevator.
Okay.
But I went up the ramp, and that you can't get in that door.
Oh.
So I went down, and there was a fellow that apparently works here that was using the ramp, and he had a key. And I said, "Excuse me, could you help me? How do I get into the East courtroom?" He said, "Oh, just go around."
Oh, good. Good. I'm glad he helped you find your way.
And we came on Grand.
Oh, really? Okay.
That's what the direction said.
That one always throws me a bit because it goes catty corner. Let me ask, hang on. Is there a way for me to mute this mic when I want to talk to my client privately?
I just want to make sure I do it right. So you'll just hold where the green light is.
Yes.
It's that button, so if you just hold it down, it turns red, and then now it's muted. So you just have to hold it down while you're talking.
Oh, and then it comes right back up when I take my finger
Yes.
off. Okay. All right.
I gotta shut off my phone too.
Yes. Okay. So what's your question on this?
Okay.
The question was
Veronica, did you get the electronic jury questionnaire and responses as well as the walk-in report? Could you print out the walk-in report for me?
yeah, so this is what I listed,
Oh, actually, I don't need the walk-in report. I thought it was going to be another blank list.
because we had legal fees.
But I need to redact it to give to them.
Right.
Yeah,
Okay,
but
that's gonna
here's the
take me
thing.
just a little bit.
You weren't receiving your payments at that time, which you didn't realize was caused by that. Yeah, so you're missing one.
This second list has the ones that are,
You said you had no financial hardship, but you were missing a bunch of money.
I recognize the names. These are some of the ones from Friday. I wonder if they put the entire list together.
I have 4 names that you sent me.
Yeah, but look at the other list. Look at the Excel spreadsheet.
Thank you.
This
There are ones on here that we struck on Friday.
Oh, yeah, that's the one that they sent. I think showing that you've been doing and having.
Oh, I'm in the, I was in the walk-in report. Let me go to it. Let me get a list.
Is this your account or
I'm going, number 7.
I've mostly got.
Yeah, it contains all the names of the ones that we struck on Friday.
Whose account is that?
Oh, I bet this is,
Am I connected to a printer?
No,
no.
I don't believe you are.
Oh.
Let me just double check with Jenna.
Oh,
To the side. I didn't notice that. Thanks.
this is an attorney-client privilege communication, so you can review it just.
Yeah.
If you're not connected, this is the answer.
Thank you.
Hopefully you can read that.
I'm sure I will. Thank you.
But you never received.
No, Judge Bainola said it's not connected to a printer.
Will you print out that Excel spreadsheet for me?
Mm-hmm.
I'm not sure.
Purchased by John. I think that's what I got.
Paying it to the local county sheriff's office for some reason.
Okay, that was probably for, that case was Katzman.
Oh, yeah. Absolutely.
This is the parcel numbers. The house.
You want the names on yours?
Yeah, I want the whole spreadsheet the way it looks right now, so that way I can compare it to the one I had on Friday and figure out which ones on that spreadsheet shouldn't be on there.
Did you have that one?
Yeah, if you wouldn't mind.
Okay, look at where we resigned it.
Right, did he send this directly to you?
I don't
You, I think he was copying you. So it's addressed to. Yeah, I have some version of this, might be an email to me. But I am gonna ask him, so he will resign until 2018.
It prints on several pages, but.
Something the court asked us to fill out, I need some help from you on.
Okay.
Because a jury's been requested, they want information about your name and address and social security number because we have to pay a portion of the jury fees.
Okay.
So what,
But I won't know his social security number.
I just need yours.
Oh,
Yeah, so what's your address?
here, I can fill it.
Okay,
And so the reason they have the ones that are struck on there is because they need to have a completed questionnaire. My understanding is that we have a completed record of all who have been completed in questionnaire. including those that are struck. The PDF is made available in order to better quickly find the new responses provided. I apologize for the inconvenience. Please let me know if you want help sorting through them. Okay, so the PDF, that's what we got in just now.
So did they actually have those jurors here?
As far as I'm aware, yes, these are the walk-ins.
No, the ones that were struck on Friday, are they physically here?
Let me check with him. I don't believe so, but I believe that they already told them not to come, but I will.
She filled this out. I'm assuming this is for the other party. Oh, so do I need to fill something out here then, or just for Donna?
No, just those two forms.
Okay, so that is just two.
So you want two?
Yeah.
You want two of these?
Yes, one for each.
Oh, I see, for the estate and for Donna. I get it. Okay, I didn't see that. So we just need to do the same information again, because one of these was for the estate and the other was for you personally.
I believe it. David said he was going to bring it, but I could be wrong. But I will focus on that as soon as I clear all these names.
Good morning.
There you go. I gotta find something. I'm gonna step out and use the restroom.
Commissioner, the ones that were struck on Friday are not here.
All right. Thank you. Well, if there's only 4, they might as well just bring them up and ask them here. There's no reason for us to go through that exercise again.
Would you like me to go down and get them?
Yeah.
If he needs that,
Okay.
I've got my phone. I'll be back.
Okay.
The very best to you today.
Thank you. Likewise. I put electrolytes in my. Yeah, I have some if you want. It's grape flavored.
Pardon?
It's like a flavoring. It's a grape flavor.
Oh,
If you want that in yours, I'm
no,
happy.
Michael was fine. Thank you.
So it gives me electrolytes.
Okay.
Unfortunately, so that'll take a few minutes.
Okay.
And by that would splash. It has the electrolyte.
All right, let's go on the record. We are on the record in the matter of the Johansson versus Castavelli matter, CV 20170554990. Council, please announce.
Good morning, Your Honor. Brian Easton on behalf of Donna Johansson personally and Donna Johansson as the personal representative of the estate of Gary Johansson.
Thank you. Good morning. Good morning, ma'am. May I have your name, please?
Donna Johansson.
Thank you. Good morning, sir. May I have your name, please?
Nicholas Casavelli.
Thank you. Good morning. Good morning, ma'am. May I have your name, please?
Galena Costello.
Thank you. All right, so what we have going on right now is that the jurors are downstairs. My assistant Veronica is going to go down and get them. They have a different jury numbering system now, so they're given a 9-digit number that we need to compare with our sheet so we can make sure that this 9-digit number matches up with number 1 or whatever card they're holding. And some of them are going to be out of chronological order because the list that they gave us had the people that were struck on Friday. So when Veronica comes up, what I'm going to have her as well as my bailiff do is go through those numbers to make sure that they match. We're going to have 27 jurors here to pick from today. We're going to impanel 10. So for the first couple of minutes, please, I indulge you to be patient just for a few minutes so that we make sure that their juror number and their actual card match up. Emma, did you gather the jury fee form? Did you all fill out the jury fee form that was on the table? We need to have your address on there. You don't have to put your social security number if you don't wish to put it on there, but we need the rest of the form filled out for the jury fees. Thank you.
Just that. Just that. Want a different pen?
Do you need an extra pen?
No, I just wanted to know if you wanted a different one.
The person in the jury assembly room said it will take them 5 to 10 minutes to assemble the list, and they'll be on their way. So if anybody needs to use the restroom or step out for a minute, you have some time.
Thank you.
You're welcome.
Veronica said she just wants to make sure she understands it.
No.
2 minutes to do all.
You bet.
I'm still battling some irregularities, so I'm going to keep doing some race sets. How are we doing time-wise?
The jurors are coming up now.
Okay.
So we don't have much time.
Okay.
Do you want to keep it on FTR? Do you want to keep it on Teams?
So right now, it's a question of the video going to Teams from the courtroom.
Okay.
Is that something, like typically in a jury situation, maybe we would have off anyway? Is this something,
When I'm selecting a panel, they're not gonna be on video anyhow, it's gonna be free. So that was just wondering. Right, on me during jury selection, because they can't be televised.
okay, so we're kind of okay.
Okay, during jury selection, yeah.
Yeah, so then, and then theoretically we would have a break after that. Theoretically. Okay. I keep working on it,
Okay,
and then, we'll.
just let me know.
Sure thing.
Emma, did you get my last email? If you would print out that last sheet, and then Veronica can line them up in the hallway according to that sheet
Okay.
before they come in.
We just run out of the new teams for her.
Okay.
So we're kind of taking check boxes off our list of things that we need. She's not going to school. And no videos going in, so fill the courtroom. So we'll give her that. Right now, and then next break, we'll come in and do some more resets. I'm gonna go talk to my guys.
Okay, thank you. Yeah. Not with your information on it.
Oh, okay.
I believe, I'm not certain.
Okay, let me get this.
Also, as far as this goes, I'm not because I know you did with me, so it's just, no, they go right 1 through 26
Okay.
on your sheet.
Okay,
That's for
1 through 26. Got it. Thank you.
Yeah, thank you.
And parties, just for the record, number 1 is going to be seated in this bottom row. So we're going to have 1 down here, 1 through 7 in the front, 8 through 14 in the back, and then we'll pick up over here and go this route, just so you all are aware.
And you don't have to have that memorized. They'll have numbers with them
Yes.
as well. Go ahead and bring them in.
Thank you. Taken, that way they don't see anything. All rise. Head all the way down to that very front row. Number 8, you can call me Kathleen, go all the way down. Oh, I can fit one more. I'll just leave it. Perfect. I think we're good.
Good morning, everyone. Please be seated. This is the time set for the trial in the matter of CV 2017055490 in the matter of Donna Johansson and the estate of Gary Johnson versus Nicholas Casavelli and Nicolina Castelli. Would all prospective jurors please stand and be sworn?
Please raise your right hand. Do you and each of you solemnly swear that the testimony that you are about you and each of you solemnly swear that you will true answers make to all questions asked by the court and counsel touching upon your qualifications to serve as a trial juror in the case now on trial, so help you God?
Thank you. Please be seated. Is there anyone on the jury panel who has a hearing impairment or other disability that would affect your ability to sit as a juror? I see no hands. Does anybody here have trouble understanding the English language to the degree that would affect your ability to sit as a juror? All right. Please stand, number 7. Yes. Do you speak English? No. Any objection to striking 7? Doesn't understand the language?
No objection.
All right, 7, you may be excused. I see no other hands. Is there anyone who's not hearing or understanding me so far? If so, please raise your juror number. I see no hands. We are now going to begin the jury selection process. You will be asked some questions about yourselves. These questions are not designed to pry unnecessarily into your personal lives or affairs, and I hope they do not. It is necessary for me to ask the lawyer and parties ask you these questions to find out if you have any knowledge about the case or about any of the persons who might be involved in it, to find out if you have any preconceived opinions about the case which you might find difficult to lay aside, and to find out if you've had any personal or family experiences that might cause you to identify yourself with either of the parties. In other words, we ask these questions to do all we can to assure that each party that the jurors selected to decide this case are able to be fair and impartial jurors. Please do not withhold any information in order to be seated on the jury. Do not be concerned with whether your answers are right or wrong. This is not a test. Just be honest and candid in your answers. Do not be concerned with what you feel the lawyers or I might want to hear from you. If your answer to a question asked of the whole panel is no, you need to do nothing. If your answer is yes, please raise your juror number. I will then call on you and ask additional questions. When I call on you, please state your juror number before answering, and please stand. If at any time a question is asked for which you have a yes answer, and for whatever reason you prefer not to answer the question in open court, please raise your number anyway. When I call on you, state your juror number and advise that you have a yes answer and you prefer to answer the question in private. At an appropriate time, counsel, the parties, and I will discuss this matter outside of the presence of the other jurors. Before we go any further, I want to introduce the staff for this division. My bailiff to my far left is Miss Emma Baxter. The bailiff assists us in getting to the courtroom on time and helps with many other tasks. We also call Emma's position courtroom assistant. My judicial assistant is Veronica Ledesma. She's seated next to Emma Baxter. She also doubles as the court's second bailiff. If you need anything during the trial, either the bailiff or the judicial assistant would be happy to assist. The clerks that are handling this trial are Elizabeth Wolf and Marcus Robinson. Amongst other things, they keep the official record of the proceedings, handle all exhibits, and swears the witnesses and jurors. My name is Christine Molyneux. I'm a Superior Court Commissioner. By chance, does anybody know me or anyone on my staff or the clerks? I see no hands. I'm now going to ask those seated at council table for introductions. Let's start with the plaintiff. Mr. Easton, would you please stand and introduce yourself and your client?
Good morning. My name is Brian Easton. I am the attorney for Donna Johansson. Ms. Johansson is appearing here in 2 capacities, individually and as the personal representative of her deceased husband's estate.
Thank you. Do any of you know Miss Donna Johansson or her late husband, Gary Johansson? I see no hands. Do any of you know Mr. Easton or anyone who is associated in any way with his firm? I see no hands. Let's introduce to the introductions of the defendants. Mr. and Mrs. Casavelli, can you please stand up and introduce yourselves?
My name is Nicholas Casavelli.
Thank you, sir. And ma'am, would you please state your name?
Nicolina Costelli.
Thank you so much. Do any of you know Mr. Nicholas Casavelli or Miss Nicolina Castelli? I see no hands. We know jury service is an inconvenience to each of you to one extent or another. And you know how important it is to our community that persons such as yourselves are willing to serve on juries to decide cases such as this one. Jury duty is one of the most important civic duties citizens of this country are called upon to perform. I know that you will not take this duty lightly. Please understand that Arizona law provides a juror can be excused only if his or her absence from work would substantially and materially affect the public interest or welfare in an adverse manner, or if service as a juror would impose an undue or extreme financial or physical hardship on you or someone under your care. If you are selected to serve on this jury, you may be eligible for supplemental jury service compensation. A member of the jury commissioner's office will meet with you and discuss what forms to complete and what documentation you need to provide to get approval for this compensation. If you are employed and can show the court that you are losing income and how much that loss is, you can receive your daily loss up to $300 plus the $12 per day combined with the daily mileage reimbursement. This compensation will begin the first day until the end of the trial. Unemployed and retired jurors are eligible to receive the minimum $40 per day, even if they receive income in the form of spousal maintenance, pensions, retirement, unemployment compensation, disability benefits, or other similar income. Jurors will receive compensation for days that you are instructed to report to the courthouse. Let me tell you about the schedule for this trial. The case is expected to take 8 days, concluding by 4:30 p.m. on February 1st. The daily schedule will be this Monday today through Thursday, starting at 9:30 a.m., ending at around 4:30 p.m., with a recess for lunch between noon and 1:30 p.m., and 15-minute breaks every 90 minutes or so. We will resume the following Monday, which is January 29th, and go through Thursday, February 1st. Is there anything about the anticipated length or daily schedule of the trial that presents a problem, whether it be personal, business, or health related, that is significant enough you feel the need to ask to be excused from service on this jury? I see 16, 24, and 17. Could you do white noise? Can you hit the white noise?
White noise.
Would the parties approach? Mr. Easton, would you approach? Can you hear me okay? Can you hear me okay? Okay, so we have 3 that are saying right now it's a hardship for the length of the trial. I can keep them on, you can ask them questions later, or we can let them go. Please understand, we've let 1 go. We have 9 more that can be let go before we impanel the remainder. So 1's gone now. We can let these 3 go if you all agree, or I can keep them on and you can question them later. Mr.
If it's a hardship, yeah.
Okay, and you agree as well? Okay, then we'll let those 3 go now. Thank you. All right. Numbers 16, 17, and 24, you are excused. Let me now give you a brief description of what this case is about. The parties they haven't agreed to the summary. This is my summary of the case. The plaintiffs allege that they were taken advantage of by the defendants, causing them to lose title to their rental home and other monetary damages. Defendants deny the allegation and seek to confirm the title of the rental property in their names. Has anyone ever seen, heard, or read anything about this case? Or have any of you ever heard anyone express an opinion about the case? I see no hands. Have you or any of your family members or close friends ever been involved in any way in a case such as this? I see no hands. Three, go ahead, stand up, state your number, and tell us what you experienced.
3.
Yes.
It wasn't an official case, but when my grandma died, my grandpa was really, really sick because it was a car accident, and my aunt stole close to $400,000 from him.
Would that experience influence you siding with one side or the other today?
Absolutely.
Without hearing the evidence presented before you, you would feel inclined to side with one side or the other?
Yeah, because it's still happening.
Thank you. You're welcome to have a seat. I see no other hands. Is there anything about the nature of this case that would make it difficult for any of you besides 3 to serve as a fair and impartial juror? I see. Sir, go ahead, stand up, state your number, and tell us why it would make it difficult for you to serve as a fair and impartial juror.
It's just, I had recently been involved in a lawsuit. I don't know if that.
And would that cause you to side with one side or the other in this particular case?
Probably not.
Oh, probably not was your response? Okay, thank you, sir. Okay. The following witnesses may testify in this particular case. Christine Swisher, S-W-I-S-H-E-R. Jared Tosterud, T-O-S-T-E-R-U-D. Marina Reed, R-E-A-D-E. Ignacio Herrera, H-E-R-R-E-R-A. Robbie Goldman, G-O-L-D-M-A-N. Jessica Powell, P-O-W-E-L-L. Peter Jackalor, J-A-C-K-A-Y-L-O-R. Dr. Pamela Wilson, W-I-L-S-O-N. Lois Allman, A-L-M-O-N-D. Lauren Greenberg, G-R-E-E-N-B-E-R-G. Luis Cota, C-O-T-A. Christopher Adams, A-D-A-M-S. Do any of you know or think you might know any of these people? Stand up, sir. Please state your number and which person do you think you might know?
10, possibly Christopher Adams.
And if you know Christopher, the particular Christopher Adams in this case, would it influence your decision in this matter?
I don't think so, no.
Thank you, sir. Adams. You're welcome to be seated. Thank you. I am now going to tell you a little more about your job and duties today as a juror. In deciding the facts of the case, the jury will have to evaluate the testimony of the witnesses. At trial, you will be directed to consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you will be directed to use the tests of accuracy and truthfulness that people use in determining matters of importance in everyday life. Is there anyone who could not judge the testimony of each witness by the same standards? I see no hands. Is there anyone who would be unable to follow the law, as I read it, to you in the instructions, disregarding your own notions or ideas about what the law is or what the law ought to be? I see no hands. If selected to sit on this case, would you be unable or unwilling to render a verdict solely on the evidence presented at trial? I see no hands. Do you have any philosophical or religious beliefs that make it difficult to sit in judgment of others? I see no hands. If you are selected to sit on this jury, you will not be allowed to do your own research or gather your own information of any kind about the case. You must decide the case based on the evidence presented in court. This means no independent experiments, no computer or social media research about the case or people involved. For example, you can't look up facts of the case on the internet or look into anyone involved in the case on Facebook or Twitter. You're not permitted to talk about the case with anyone. Do these prohibitions present a problem for anyone? I see no hands. Does anyone know any other members of the jury panel? I see no hands. Defendants are representing themselves at trial. They are not lawyers. That is their right. Anyone believe that they would be biased for or against them for that reason? I see no hands. Would the parties approach again, please? White noise. I have 2 questions for you. Number 3, do you believe we should let her go for cause at this time or bias? Yes, sir? Do you see you're nodding yes, you as well? You do? All right, all 3 agree yes. Those 3 will be gone for cause. Number 10 said he might know Adams, but he didn't think there would influence him one way or the other. Do you wish to keep him or let him go?
Depends on how he knows him.
Yeah, we can keep him on. You can ask him some questions later.
There's a lot of people with that name.
Yeah, exactly. So we'll keep him on. We'll let 3 go. Now, I flew through my questions. If you all want to ask your voir dire questions at this time, we can do so. Or if you'd like a few-minute break.
Number 14 probably should be considered letting you go.
Oh, 14.
Which one was that?
He was the one,
Involved in a lawsuit.
Yeah, he said he was involved in a lawsuit, and I told him that experience caused him to side with one side or the other in this case, and he said he didn't think so. Do you want to do some further questioning? All right, so we'll let 3 go, and if you want to ask any follow-up questions of 14 or 10 at this time, we can do so. And then do you guys want to take a break after that, or do you want to ask your own voir dire questions?
Ask her own.
So let me talk about that while you're here. Some of yours, both of yours, some of them, the questions I've already asked are in your documents. I believe this one is yours. Yeah. The only 2 that you can't ask are these, because those aren't going to the jury. Actually, this one I'll allow you to. Take this back. I'm going to allow this. I said on Friday I would not allow this question. I'm going to allow it because your witness is going to be testifying as to the vulnerable issue, correct, counsel? So I'm going to let you ask that question. The only one that you can't ask is this one, but you can modify it because I've allowed, you can ask the question with these items in it. Anyone here been sued now or in the past for a quiet title or consumer fraud or fraud? Because that's the 3 that they're going to hear. But they're not going to hear about these. Does that make sense, the modification? So all yours are fine. Some of them are duplicative, so you might not want to ask the same things I've already asked. But this one can be asked, anyone here now or in the past been sued for a quiet title, consumer fraud, or fraud? Because that's the 3 claims that they're going to hear about. Does that make sense? All right, so what we'll do is we'll let 3 go. If you want to further question 14 and 10, you're welcome to do so. And then we'll roll into your voir dire. Plaintiff, you'll ask your questions first, then you can ask your questions after. Do you have a copy of this with you? Do you want my copy?
Please.
Yeah, you can have it. All right.
I wasn't sure if we were supposed to bring them.
Yeah, and you can. But if you're missing anything, I printed out pretty much everything because I like hard copies and stuff. I'm sorry I wrote all over it, but if you need something, let me know, all right? Okay. You're welcome. Have a seat.
Thank you.
You're welcome. All right, number 3, you're excused at this time. Thank you for your service. The parties are going to ask a couple follow-up questions to juror number 14 and juror number 10. Plaintiff's counsel, did you have any follow-up questions for 14 or 10?
Yes, if I might, Your
Yes, sir. Go right ahead.
Juror number 14, what kind of lawsuit were you involved in, please?
I can barely hear you, dear. Can you speak up loud?
Apologies.
Thank you.
Juror number 14, the lawsuit I was involved in was a wrongful death case of my father.
Okay.
Thank you.
No further.
And any questions for 10? He's the gentleman that might know Mr. Adams.
Yes. Juror number 10. Oh, there you are. What city is the Christopher Adams you know live in? Do you know?
10, I'm not sure what city. The Christopher Adams I know was a store manager at Fry's.
Okay.
That helps, I don't know.
Think so. Thank you. Appreciate it.
You're welcome to do any follow-up questions that you may have.
You're 14. You're a plaintiff or defendant in the case?
Juror 14, plaintiff and defendant are, we were the ones suing the company for wrongful death.
So plaintiff, yes, sir.
Okay.
Thank you.
Juror 10. Mr. Adams, do you know him in any other capacity than a store manager?
10, no, I do not.
Thank you, sir. All right. Now, the parties are going to be able to ask you a few questions, so please give them the same courtesy. If they call on your number, please stand up, say your number, and answer the question. Counsel, you may proceed.
Thank you, Your Honor. Is anyone here a medical professional now or in the past? Juror number 6. And what's been your,
I'm a nurse
you're a nurse, now or in the past?
now.
Okay. We're going to have potentially some testimony from medical professionals. Would you have any problem following their testimony based on your experience as a nurse?
I don't think so.
Okay, thank you. Is anyone here related to a person who is a medical professional now or in the past? Okay, I'll start here with number 4, and you can put your hands down, and I'll ask you to raise them back up in a moment. Sir, number 4, who's related to you as a medical professional?
My spouse.
Your spouse.
Yes.
And what's her occupation?
She's a director of rehab for a skilled nursing facility.
Very good. Thank you. Number 8, I think, was next. Ma'am?
Juror number 8, my uncle is an eye surgeon.
An eye surgeon. Okay, thank you. Number 10, I think, also.
10, my mother was a director of nursing.
At a hospital?
Yes, Banner specifically.
Okay, thank you. And I think there were some others here. Number 14, who are you related to that's a medical professional?
14, my aunt is a nurse for Mayo Clinic.
Okay, thank you. And then number 18?
My sister is currently a psychiatrist.
Your sister is?
Yes.
And what, does she work for a hospital or is she in private practice?
She works in the behavioral sciences at University of Nevada, Las Vegas.
I'm sorry, she works in what sense?
She's in the behavioral health department at UNLV, University of Nevada, Las Vegas.
Okay, thank you. And was there anyone else? Number 26?
Yes. My granddaughter is an ER nurse and my son is a pediatric.
Okay, thank you. Have any of your family, friends, or co-workers been, in your opinion, wrongfully accused of mishandling another person's money or assets?
I see no hands for the record.
Anyone here listed on the Adult Protective Services Registry?
I see no hands.
Anyone here being sued now or in the past for fraud, consumer fraud, or a quiet title action?
I see no hands.
I think the judge or the commissioner answered or asked this question earlier, but I'll ask it again just in case. Anyone here have any preconceived notion about the parties in this case? See no hands?
No hands.
Anyone here have any preconceived notions about what the outcome of this case should be?
I see no hands.
Anyone here who feels that they cannot be fair and impartial in their service as a juror?
I see no hands.
Anyone who feels that they cannot give their full, complete, and undistracted attention to this case while serving as a juror?
I see no hands.
Anyone here who served, oh, I think we've asked that. Or any prior jury duty by anyone in this case? Number 14?
In this case specifically.
Besides this case, have you ever served as a juror? And what kind of case was that, please?
14, it was a criminal case in Gila County.
And do you recall what the nature of the charges were?
It was possession and possession with intent to sell for heroin.
Okay, thank you. We'll go with number 12. Sir?
I was on a jury a number of years ago here in Maricopa County. It was a criminal case. The verdict was guilty.
Do you remember what kind of, what they alleged the person of?
Child endangerment, I believe.
Okay, thank you. And number 11, ma'am?
Yes, it was a criminal case for a molestation charge, and the verdict was guilty.
Okay, thank you. Is there anything about you and the experiences in life that you have had up to this point that you think we ought to know about because it may affect your decision in this case? Number 14.
14, the lawsuit I spoke of earlier, a lot of it had to do with, I had to be with my mom through the whole process of losing my father, and the hardships that she endured through that whole process was a lot. There was monetary hardship, it was loss of my dad's pension, I think it was a pension. She just struggled a lot with losing her dad, or my father, my dad. And that is just a personal experience I've had that might impact this. I'm not sure.
So you think it might impact you, but you're not sure. Is that what I just heard you say?
Hearing that she lost her husband, I might be able to sympathize because my mother lost her husband.
Sure. Okay. Thank you, sir. Anyone else? I think that's all my questions.
Thank you, sir. You're welcome to ask your questions.
Mostly you've asked.
Yeah, a lot of, you just ask, if you have some, you're welcome to do so. You're not required to ask anything. It's up to you.
Does anyone here have any type of bias towards the court system?
And can you all hear him okay? Okay, yeah, you're kind of quiet. If you could use your mic, that'd be great.
Does anyone here have any type of bias towards the court system?
I see. Oh, go ahead, sir. 14?
14, maybe. My aunt works for the Superior Court, civil.
Thank you, sir.
Allowed to ask who?
No, we don't need to know who.
Does anyone here have any bias towards race, religion, color?
I see no hands.
Does anyone here have any special needs that would affect your decisions in this case?
I see no hands.
Is anyone here a government employee?
21?
I work for the city of Phoenix.
Any follow-up questions, sir?
What department for the city do you work?
I work for the Planning and Development Department.
Has anyone here ever practiced law or been a lawyer?
I see no hands. Oh, I see half a hand, 24.
Now I'm a retired
26.
litigation paralegal.
Okay.
Thank you. That was 26, thank you.
You missed him.
No, she answered.
24 too?
No, that was just 26. I misspoke. It was only 26, yes.
I thought I saw another one.
Has anyone here ever been an agent under a power of attorney?
I see no hand. Oh, I see a hand now. 22?
Yeah, juror 22, both my mother and my father's, they got older. Passed.
Thank you, sir.
Yes, that one. Is anyone here who has a relative that would be considered a vulnerable person?
I see 1 and 15. Go ahead, sir.
What is the relation?
She's my elderly grandmother. She's living alone, so she could be taken advantage of. And,
Would that affect your ability to make a decision in the case over the evidence?
it could.
Did you want to ask him any other questions?
No, that's about
Okay,
it.
and I saw one other card, number 15. Yes, sir. If you could please stand up and tell us.
Care 15. Yeah, my grandfather lives in a memory care facility. Certainly a vulnerable person.
So he has an assisted living?
Yeah, in a memory care facility. Yeah.
Okay.
Thank you.
Okay.
Any other questions?
No.
All right, thank you. All right, now, ladies and gentlemen, on the back of your juror numbers are some questions. I'm going to ask each of you to answer it in turn. When it's your turn, I will call on your number. Please stand, answer all the questions. If you or your spouse is retired, please tell us the occupation prior to retirement. If you have served on a jury before, please tell us the kind and type of case it was, if it was a civil car accident or criminal bank robbery, details like that if you remember. Please also tell us when and where the case was tried, whether there was a verdict, and what the verdict was if you can recall, and whether you served as a foreperson of the jury. Let's start with number 1. If you could please stand, state your juror number, and answer the questions on the back of the card, I'd appreciate it.
Juror number 1, my occupation, I work for the Scottsdale Princess Resort. I've worked there for 10 years, and then I am a sous chef, so I work in the restaurant. I have no children. My marital status is married. My spouse works for PayPal. She's only worked there for about 6 months, and then she works in fraud and compliance. And then I have never sat in a jury before, and I have never been involved in a lawsuit.
Thank you, I appreciate your time. All right, number 2, stand, state your number, and tell us the answers.
Number 2, I am a construction worker for 4 years. No family, no children. I'm single. Have been in a jury before. It was a criminal for possession of drugs, and I have not been in a lawsuit before.
And do you remember the verdict, whether it was guilty or not guilty?
Guilty.
And was it here in Maricopa County?
Yes.
Thank you so much. Juror number 3. Actually, 3 is gone. 4.
Juror number 4, work for a company called TechFlow, do inside sales. I've been there for about 9 months. I have 3 children, 11, 9, and 6. I am married. My spouse works for Diamondback Healthcare. She's been there for about almost 2 years. She's a director of rehab at a skilled nursing facility, and I have not been on a trial as a juror before.
Thank you so very much. Juror number 5.
Hello. I work for Hugh Freedy. I'm a quality engineer. I worked there 3.5 years, making medical devices. No children, single. Let's see. I was on teen court when I was a teenager, which was this experimental court 30-plus years ago, probably totally irrelevant. Yuma County.
Thank you so much. Juror number 6.
Juror number 6, I'm a nurse. I worked for the hospital for 10 years, and I work for United Healthcare now. I have 2 kids, 8 and 10. I'm married. My husband does commercial air conditioning, and I've never been on a jury before.
Thank you very much. Juror number 8.
Juror number 8, I work for Copper State Bolt and Nut Company. I've been there going on 3 years, and I am an HR generalist. I have 1 child, 8 months. I am married. My spouse does work for the county Parks Department. He's been there for about 2.5 years, and he is a park ranger. I have never sat as a juror, and I have never been involved in any lawsuit before.
Thank you very much. Juror number 9.
Juror number 9, I'm an author. I've done that for 8 years. I have 3 children. They're 17, 15, and 10. I'm married. My husband works for Isogenics. He does purchasing. I've never been a juror, and I've never been in a lawsuit.
Thank you very much. Juror number 10.
Juror 10, I work for PayPal. I'm a senior agent in global customer service. I've been there for 4 years. No children. I am married. My wife works for Fry's Food and Drug. Been there 22 years. It's retail. And never been on a jury or in a lawsuit.
Thank you. Juror number 11.
Juror number 11. Retired, married, husband, retired, and I've been on a jury criminal case, and I've never been in a lawsuit.
And what was your occupation before retirement?
Accounting, in accounting.
Thank you. And the trial, do you recall what the verdict was?
Guilty.
Thank you. Juror number 12.
Juror number 12, I'm retired. Before that, I was in security 8 years. I'm single, no children. I've been in a jury before, a criminal here in Maricopa County. The verdict was guilty. I was not the foreman. And I've never been involved in a lawsuit.
Thank you, sir. Juror number 13.
Good morning.
Good morning.
I work for Avnet Electronics. I've been there 17 and a half years. I'm a pricing specialist. I am married with 3 children. My husband is currently working for Honeywell as a contractor. I've never sat for a jury. However, I have been in a lawsuit, theft by means of transportation, and the defendant was guilty.
Thank you. Juror number 14.
Juror 14, I work in IT, data center and IT infrastructure for Banner Health. I've been there for about 2 years. I don't have any kids. I am not married, single. I have sat as a juror before. I was a criminal possession and possession with intent to sell case, and we did deliver a guilty verdict. I was not the foreman, poor person. And like I said before, I was part of a wrongful death suit for my father.
Thank you, sir. Juror number 15.
Juror number 15, I'm a student, full-time, not married, no kids. I've never sat as a juror before, never been involved in any type of lawsuit.
Thank you. Juror number 18.
Juror number 18, I'm a lab tech at Caris Life Sciences. I've been there for 5 years. I have 2 kids, 1 and 2, and I am married. My husband is in sales with Red Rock Machinery Group, and he's been there for 2 years. And I have not been in a jury or in a lawsuit.
Thank you very much. Juror number 19.
Number 19, I'm a dental assistant. I've been there for 2 years. Wickenburg Family Dentistry. No children, single, and never been a juror or in a lawsuit.
Thank you, juror number 19. Juror 20.
Number 20, I worked for OnSemi for the past 4.5 years as an HR specialist. Single, no children. First time as a juror, and I have not been involved in a lawsuit.
Thank you very much. Juror number 21.
Juror number 21, I work for the city of Phoenix. I've been there since approximately 2017. I'm a GIS coordinator, Geographic Information Systems, so essentially making maps. I have no children. I'm single, so no spouse or significant other. I've not sat for a juror before, and I've never been involved in a lawsuit of any type.
Thank you, sir. Juror number 22.
So, excuse me, juror number 22, occupation is, my employer is Vantage Mobility. Been there about a year and 4 months, senior buyer, divorced, have not sat on a jury, and have not been involved in a lawsuit.
Thank you, sir. Juror number 23.
Juror number 23, I work for a company called Eswell Exotica. I've been there 12 and a half years. I work as a senior regional manager. It's an optical company. I am married with 2 children. One is 15, the other is an adult. My husband is retired, and I haven't sat as a juror before and have not been involved in a lawsuit.
Thank you very much. Juror number 25.
Juror number 25. Been a stay-at-home dad for the past 5 years. Before that, I was a software developer at U-Haul. I have 2 boys, 12 and 14. Not married. I have not been a jury before, and I have never been involved in a lawsuit.
Thank you. And juror number 26.
Juror number 26, I was a litigation paralegal, insurance defense, and med-mal defense for 34 years. Now, since I retired, I have a business doing medical and legal transcription. I have 3 children, all adults. I'm divorced. I've never sat on a jury, and I haven't been involved in a lawsuit.
Thank you very much. For those of you that have prior jury experience, is there anything about those former trials that would make it so that you could not be fair and impartial in this particular case? If you believe so, please raise your card. I see no hands. We are now about to conclude jury selection. But let me ask one last question. Sometimes, by the time we get to the end of questioning, the jurors will have remembered additional answers to questions that were asked earlier. Then they wonder if they should give the answers or not. Please give the answers. If you have anything in mind now that you are wondering if you should tell me about or wish you had said something earlier, now is the time to do it. Please raise your card. All right, let's start with number 12.
If I'm selected, if some of them, they have very low voices, if they could use their microphones.
I will make sure they use the microphones. It's hard for me to hear as well. Thank you, sir. All right, 14.
14, I forgot I have another aunt who is a dentist.
Thank you very much. And in the back, 26.
Yes, there was a question asked before about adult protective services, and it didn't apply to me at that time, but I do, some of the transcription work that I do is for psychologists who do work evaluations for APS.
Thank you. Ladies and gentlemen, we are now going to take a short recess to complete the process of jury selection. There are many reasons why a juror is selected to serve, so don't take it personally if you are not chosen to serve as a juror in this case. Only a set number of you can be on this jury. My assistant is going to have you wait outside. We will call you back into the courtroom to be seated. During the recess, do not talk about the case amongst yourselves or with anyone. We estimate the recess will take about 15 minutes. Thank you. All right, thank you. Please be seated. Let the record reflect the jurors are excused in the hallway, and we have the parties present. All right. Earlier, we did strike 3, 7, 16, 17, and 24. Now we're going to discuss whether there are any additional challenges for cause or hardship. I'll start with plaintiff. Any for cause or hardship?
A moment, please, Your Honor. I'm
Sure.
looking back at my notes here. No, Your Honor, I don't think so.
Very well.
So cause and hardship.
Cause and hardship, yes, sir.
I don't think so.
Okay, defendants, any that you believe should be struck for cause or hardship?
Juror number 1.
Juror number 1 said may be biased. Plaintiff, do you have a position?
Yeah, I know he said he might be biased, but I didn't hear him say outright that he was. I'm not sure that that's enough to arise to cause. All right. I think he's just...
He indicated he may be biased. Grandfather was a vulnerable adult. It's on the fence, but I'm going to grant defendant's request to strike 1 for cause. 1 is struck for cause. Any others for cause or hardship?
Number 14, because he said bias against court system, mother's hardship, death of her spouse. And
He just
said-
appears he don't want to be here.
Yeah.
Plaintiff's counsel position as to cause or hardship on 14?
I don't know that it rises to the level of cause, but I understand he's had numerous answers on this that are concerning.
Going to grant your request. 14 is struck for cause. Any others for cause or hardship?
22.
And what did 22 say that you're asking to have him struck for cause or hardship? Go ahead, sir.
He's a power of attorney for his parents.
And possibly 13, because of what she just said about death by transportation, lawsuit of...
Let me get plaintiff's position on 22, then we'll go back to 13. What is your position with regard to 22?
I don't think being a power of attorney rises to the level of cause in this matter. He didn't indicate any bias or any inability to render a judgment, so I don't believe there's any cause there on 22.
All right, your response?
He wasn't asked that either, so it could be leaning because of a power of attorney and the allegations of power of attorney in this issue.
We'll let 22 go for cause. You said 13. Go ahead and make your argument.
13.
She said something about death by transportation lawsuit that she was in. I'm not sure what that was about. She was a juror.
Plaintiff have a position? 1, 2, 3, 4, 5, 6, 7.
I don't have much in my notes about what she was involved with prior, but I think just being involved in a prior lawsuit I think that's the allegation. I don't know that rises to the level of cause, and it was a criminal trial, not a civil trial.
Go ahead, sir.
It was the type of trial. She was a jury. His conviction that she had said the outcome was is basically she didn't feel comfortable in her words in speaking as well.
Body language.
We'll let 13 go for cause. Any other for cause or hardship?
26.
26 said something about doing transcripts for litigation.
For adult protective
Adult
services.
Protective Service.
And you believe that she should be let go for cause as a result of that?
There was an allegation through Adult Protective Service through this and investigations.
Plaintiff's position?
No objection.
26 will be let go for cause. Any other arguments?
What do you think?
1, 2, 3, 4,
Was number 10 retained or let go?
Not let go yet. That's one that possibly knows Adams that works at Fry's. I don't know if that's the same Adams. You all would know.
Mr. Adams has had a few different types of careers.
Yeah. It's possible he might know him.
I don't know. I don't know if he knows him.
I think because of the uncertainty of not knowing whether he knows one of the potential witnesses, I think it would be appropriate to strike.
Would you like to let him go?
I don't think that would be adequate because it could be someone totally different, and it's a Fry's store.
Well, let's play it out. What if he does know the person? Does that change your position?
No.
Okay.
No, not really. I mean, it depends if there's bad interaction between the two of them or what. It's,
But you won't be able to ask him any further questions.
Right.
Do you want to call him in and ask him further questions?
I don't think that's necessary. I think he'd be okay.
You want to leave him, plaintiff's counsel?
I think he should be stricken just in the office.
We have room. We'll strike him. 10's gone. So that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 we've done. 11 out of 26. That leaves us with 15. We need 10. Any other arguments for cause or hardship?
I forget his number in the corner. Said he worked for the city.
In the front or the back?
That corner.
Okay, go ahead. I know who you're talking about.
He works for the city, and it might be considered conflict just because it's a government worker.
Does your case have to do with government work?
No, just if it's a juror sitting on a panel for this type, and it's a city worker,
Okay.
it could be considered some type of bias, even though it's maybe not directly related to the department.
Plaintiff's counsel, your position as to 21?
I don't see any kind of conflict between what he does for the city of Phoenix and being here in the jury.
I don't think I'm understanding your argument for cause.
Well, anybody from an objectionable point of view would see that a government worker sitting on a juror in a civil trial might be considered a conflict or have a somewhat biased interest because they're a government employee.
We'll let him go. 21's gone. Cause.
What about the
Any other arguments? 1, 2, 3,
The
4, 5,
young man in front of him, too. I don't know if his number's 15.
He was 15?
I think so.
He's a student?
Mhm.
What's your argument as to him?
I may have got that one confused.
Thin gentleman, dark hair, is a student?
Yeah, I think it was a pink shirt.
Yeah, that's 15.
He said something, I can't remember exactly what he said, but.
3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
It was something that raised a little concern.
Which one said that they had a relative in skilled care?
That
Two
was
of
the
them.
one. That was the one in memory care. He has a family member in memory care.
That's number 4.
So number 15, was it? The front row, back corner here.
Was that 15?
It was 15. Grandfather lives in a memory care.
Okay, and you're asking to be struck for cause?
Yes.
Any position?
I don't agree that there's cause on that one, Your Honor. I didn't see the conflict. I don't see any bias.
Potential bias. I'll let him go. 15.
Number 4,
Let me-
I think it
Let me
was.
count. 1, 2, 3, 4,
He
5,
worked in
6,
tech flow,
10, 11, 12.
disabled healthcare, skilled nursing. Does that have anything?
Yeah.
If you work in skilled healthcare.
I'm sorry, any other arguments? Any other numbers?
Number 4.
Plaintiff's counsel.
Again, I don't see the potential conflict. I don't see the cause, Your Honor, so I would object.
If you're in skilled care, you're working with people of all types, vulnerable or not.
That's the spouse that works in healthcare, not the juror.
Yeah, it was the spouse.
Do husbands and wives do not discuss work at times and issues?
You're afraid 4 will be biased. We'll let him go for cause. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 2 left and we'll have a panel. Plaintiff's counsel, any position as to the remainder of the panel?
I do not think so, Your Honor.
Okay.
Juror number 3 said something about bias.
3 is gone. 3 was already excused.
Number 12, 11 and number 12.
I need to hear your arguments as to them.
I forget exactly their argument, but
12 just wants a microphone.
well, he's retired. He's says hard of hearing, and that might influence something if he doesn't understand it correctly and he doesn't ask for clarification.
All right. I'll address him specifically, but I'm not going to release him for cause. Anyone else? Any other arguments?
Number 11, I don't remember what she said because I could hardly hear her.
I think she said she was a prior juror.
You know, she prior to jury was sitting on a panel.
I'm not sure.
I forget what the claim was, but guilty verdict. So.
2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14.
I don't know if you're looking for my input on juror 11.
Yeah, go ahead.
I don't see any conflict. She did admit she served on a jury panel before, but I don't think that rises to the level of cause.
I don't think it rises to the level of cause either.
Well, jury 12, he said he lives alone, can hardly hear. That would categorize him at some point that he could associate with the allegations of vulnerability.
But he indicated he could be fair and impartial. So, all right. So
no, we all say that, Your Honor.
1, 2, 3. Well, hopefully we're truthful. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. So 2 are going to be let go. We can choose those 2 if you wish to do so, or we can just cut them off at the bottom of the list. Plaintiff's counsel, what's your position?
Can you repeat that, Your Honor? I didn't quite.
Yeah, there's only 2 left off the list that we can strike in order to impanel the jury. We can go with 11 and 12 if you wish to do so, or I can cut it off at the bottom of the list like we normally do.
So the higher numbered jurors, higher being a higher.
Exactly, would be impaneled. The lower would be cut off.
I didn't expect. So give me a specific example. What number?
Yeah, let me. So right now there was 26 jurors in here. We've just struck for cause 14.
Right.
We need 10 for the panel. So it leaves, we have, if we let all these 12 or 14 go that we've just chosen, there'll be 12 left.
Okay.
There's no other cause or hardship, then what happens is I go to the ones that are left. So 23 and 25 would be eliminated because there's 2 that need to go in order to impanel the jury.
Okay, that would be fine.
I mean, that's how the panel works. So if there's no cause or hardship, the last ones that go would be 23 and 25, and then we have our panel of 10.
I think hearing impairment would be somewhat of a hardship, at least towards us.
Plaintiff's counsel, position with regard to his hearing.
He just asked that we'd speak up. I didn't hear him say that.
He asked to use the microphone, so he didn't indicate that he couldn't hear without the microphone. So he was hearing me fine. I think he had a hard time hearing you until you used the microphone.
Well, at some point in time, it might not be right in front of a microphone.
We'll let 12 go for cause. So now 25 is gone at the bottom of the list. I'm going to tell you our juror numbers. You ready? Our juror numbers are 2, 5, 6, 8, 9, 11, 18, 19, 20, and 23. So let me just go back through these one moment, please. 1, 2, hang on a second. Let me just count this and I'll get right to you. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yes, ma'am.
From what I understand, this is an 8 jury panel?
Yeah, so 8, yes, 8 and 2. So what will happen is they'll all listen to the evidence. Then at the end of trial, when they go back to deliberate, they'll all deliberate. But only 8 of them will render a verdict. 2 of them will be let go. Does that make sense? Go ahead with your question, sir.
Okay. So if they're all listening to it, how do they figure which 8 is going to Render the verdict.
They're chosen by lot. The clerks put the numbers in a hat, and they pick out 2, and they get let go.
I guess that's a way to do it, right?
Yeah.
Okay.
Any other questions?
A
Okay.
little unorthodox, but
After we impanel our jury, are we ready to proceed with our opening statements?
When will we be taking a break this morning?
I told them we'd come back in 15 minutes, so we'll take another 15-minute break after we impanel the jury. How's that? So that way you all can use the restroom, get ready for your opening statements. Is that fair enough?
That would be fair, Your Honor.
Okay, is that enough time, sir? Okay, so let's bring them back in. We'll impanel our jurors. We'll swear them in. I will go over the preliminary jury instructions, but I won't do it. I'll let you guys get ready. You guys haven't had a break, so we'll impanel them. We'll take a 15-minute break, then we'll do the preliminary instructions. Go ahead, sir.
have all these jurors read the questionnaire?
Have all of them read the questionnaire? Yes. Yes, sir.
I'm gonna take a second break and have the jurors follow, and then we're gonna take them back and give some instructions, just so they don't go out in the lobby.
Okay. And when they come in, we all need to stand. Thanks. We're doing great on time.
All right. So I can start filling up these back seats for me. On either side, fill up those back seats.
Thank you, everyone. Please be seated. The record will reflect the presence of all parties, counsel, and the jury panel. Ladies and gentlemen, the clerk will now read the numbers of the jurors selected to try the case. As your number is called, please come forward and take a seat in the jury box as directed by the bailiff.
Juror number 2, you are now jury number 1. Juror number 5.
Now number 1.
Juror number 5, you are now number 1.
No, 2.
2, sorry.
That's okay.
Juror number 6, you're now number 3. Juror number 8, you are now number 4.
You're welcome to have a seat.
Juror number 9, you are now number 5. Juror 11, you are now number 6.
The gentleman in the back, Your Honor, can't hear.
Juror number 18, you are now juror number 7.
All the way to the very end.
Juror number 19, you are now number 8. Juror number 20, you are now number 9. And juror 23, you are now juror number 10.
Those of you who were not selected as jurors are to report back to the jury commissioner. Thank you very much for your participation here today and for your willingness to serve on this jury. You are now excused. Oh, great. You guys are released, so they let you go. Have a good rest of your day. Take care.
I'll meet everybody outside. Y'all right out there.
Would the jury please stand and be sworn?
Please raise your right hand. Do you swear that you will give careful attention to the proceedings, follow the court's instructions, including admonition, and render a verdict in accordance with the law and evidence presented to you, so help you God?
I do. Thank you. Please be seated. All right. Ladies and gentlemen, I appreciate your patience here today and your attention. The parties haven't had an opportunity to take a break. We are going to take a 15-minute break. Please understand, at all times, you are required to wear your jury badge. Don't talk with anyone about the case, each other, work, spouses, family, friends, or strangers, and certainly not the attorneys or parties. You may say that you're part of a jury and that the trial is scheduled to end on February 1st. Don't do any research about the facts or parties relating to the case. This includes the internet and social media. Don't try to look into the parties, the attorney, another potential juror, or anything having to do with this case. We're going to take a 15-minute recess, and we'll come back and go over the preliminary jury instructions. Thank you.
You guys can follow me. We're going to go this way.
All rise for the jury.
Please be seated. Let the record reflect the jurors are excused. We are in the presence of counsel as well as the parties. All right, we are going to take a 15-minute break. Use the restroom, get something to drink. I don't mind if you eat and drink in here. It doesn't bother me whatsoever. We'll start in 15 minutes, go over the preliminary jury instructions, and then I will allow you to do your opening statements, and we'll go from there. We'll take lunch from noon to 1:30 every day. Usually, I like to take the morning break between 10:45 and 11 o'clock. And the afternoon break from 3 to 3:15 if it works out. Just try and keep that in mind because the staff needs breaks, okay? So we'll see you back in 15 minutes. Thank you.
All rise.
Use the restrooms, have they?
Yes.
It's not Saturday.
Do we have like contact forms?
No, I don't have any of those papers.
Yeah, I just need to read this.
I can put those, I don't have, actually, it's like, I can put those out, I'm gonna give them whatever else you need to get.
Yeah, I was just gonna go in there and give them the sheets, that way they have all of our information. Mm-hmm. Thank you, and they were in here helping us too. I will do that in just a moment. I don't want to have to go back and take care of our journey. Yeah, absolutely. Do you need me to print it?
I'm just trying to find it. I think it's in this.
Just print 10 of those. Yeah, okay. I just don't want to leave this.
Oh, no, I understand.
And then you can come back with me, I'll get those, and you can see the spiel that we're all going.
Okay, it should be printed.
Okay. Elizabeth, we'll be right back. You're gonna remain in here, correct?
Yes, I'll be here.
Thank you.
You're welcome.
let's go. We're ready.
Mr. Easton, do you plan on producing those power of attorneys? Just a question. You can't respond to a question civilly?
I'm sorry, can I resolve something?
I just asked if he was going to produce the power of attorneys.
He refuses to answer.
He just won't answer.
I'm not sure exactly what you're asking. Power of attorneys for what?
What he's alleged in this case.
You should have all of his list of evidence, what he's going to present.
Well, honestly, Commissioner, this has changed the third time. The names and the exhibits, so it's kind of hard to keep up with.
Do you have this, the worksheet?
But it's not the one that was given before. It's changed.
So it shows 25 and 26 are powers of attorney. And
ours reads different, such as something like statement, the one that was given last time.
I want to make sure you have this.
Yes, this one you give us today is here.
Okay, I was going to say the one today, that's what we're using.
But the question I have is the one that, when we went through this with the court and they had renamed and renumbered the exhibits before,
And Judge Blanchard.
at least ours anyway, and we went down to Judge Blanchard's court and we went through it with the deputy clerk of the court, and supposedly you straightened it out. But see, that's even changed now. So now we have to try to figure out with this to rename our exhibits we have at home.
Do you want to look at your exhibit? You're welcome to look at your exhibits that are here.
Well, you may have numbered them here, but the ones we had is different. That's what I'm saying.
Okay.
So it's going to take us a minute to get caught
No
up.
problem, no problem.
And I was just simply asking if he's going to produce those because
He just didn't want to answer a civil question.
Yeah, it looks like they're listed as 25 and 6. That might be helpful.
we'll be able to object to those.
Yeah, during trial, you bet.
Okay. Will we be able to produce the originals?
If you're using that as impeachment, if you want to show that he's showing something different, you can use that as impeachment.
Okay.
Okay.
Your Honor, if I might.
Sure.
When we were here on Friday, I provided the court with copies of certain exhibits that we had gone back through and redacted further than what we previously had done, just to make sure we didn't have account numbers and so forth. And we provided that to the court, and then we left a copy here for Mr. and Mrs. Casavelli, but I don't know that they've seen those yet.
You're welcome to provide that to them. What they did was darken out. They have documents that were as exhibits that are blacked out, but they're not blacked out enough. You can still read what's underneath it. It's the same copies, just blacked out further. So he has a copy for you if you want them.
The copy was left here with the court.
I'm sorry,
so I
the
don't
clerk
know-
has it.
I don't
She's
know
getting
who
it.
has Yeah.
Are we ready? Do you need a minute?
No, we're ready. We're just talking till they come. Thank you.
All rise.
Oh, I'll do that.
Thank you.
The table behind you if you want.
I only made one, I think, for them.
I can always make an extra. I'll be over you. Thank you so much. You're welcome to be seated.
Do all the jurors have a copy?
Yes, ma'am.
Do you want to share one, or do you want us to make you an extra copy? Okay, all right, let's get started. Welcome back, ladies and gentlemen. Now we're going to review the preliminary jury instructions. Hopefully you all have a copy before you. I will review those at this time. Importance of jury service. Jury service is an important, and I'm sorry, let the record reflect that we're in the presence of our panel and the parties. Jury service is an important part of our system of justice with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience or worse, jury service is an important responsibility for you, one which I am sure you will take seriously. Duty of jurors. Ladies and gentlemen, now that you have been sworn, I will briefly tell you something about your duties as jurors and give you some instructions. At the end of the trial, I will give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from the evidence produced in court. You must not speculate or guess about any fact. You must not be influenced by sympathy or prejudice. You will hear the evidence, decide the facts, and then apply the law I will give you to those facts. That is how you will reach your verdict. In doing so, you must follow that law whether you agree with it or not. You must not take anything I may say or do during the trial as my indication of my opinion about the facts. You and you alone are the judges of the facts. Evidence. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents and other things received into evidence as exhibits, and any evidence stipulated to by the parties that you are instructed to consider. You will decide the credibility of the witnesses and weight to be given to any evidence presented in the case, whether it is direct evidence or circumstantial evidence. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise actually perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be determined. The law makes no distinction between direct and circumstantial evidence. You must determine the weight to be given to all the evidence without regard to whether it is direct or circumstantial. Rulings of the court. Admission of evidence in court is governed by the rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. If an objection to a question is sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit is offered into evidence and an objection to it is sustained, you must not consider that exhibit as evidence. If testimony is ordered stricken from the record, you must not consider that testimony for any purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility of the witnesses or the weight you should give to any evidence that has been admitted. Exclusion of witnesses. The rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over and a result is announced. This means that all witnesses will remain outside the courtroom during the entire trial except when one is called to the witness stand. They will wait in the areas directed by the bailiff unless other arrangements have been made with the party who has called them. The rule also forbids witnesses from telling anyone but the parties what they will testify about or what they have testified to. If witnesses do talk to the parties about their testimony, other witnesses and jurors should avoid being present or overhearing. The parties are directed to inform all of their witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties should keep a careful lookout to prevent any potential witness from remaining in the courtroom if they accidentally enter. Bench conferences and recesses. From time to time during the trial, it may become necessary for me to talk with the parties out of the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide on how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant a party's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test for accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, and whether the witness is contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all the evidence in the light of reason, common sense, and experience. Expert witnesses. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Juror note-taking. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You should pay close attention to the testimony as it is given. You should have been provided with notepads and pens. Has that happened? Okay, good. The court encourages you to take notes during the trial if you wish to do so. Do not let note-taking distract you so that you miss hearing or seeing other testimony. You may use your notes during your deliberations at the end of the trial. Until then, please keep your notes to yourself. During recesses in the trial, you may leave your notes on your seat. Your notes are confidential and my bailiff will guard them. No one will be allowed to read your notes. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of other jurors. After you have rendered your verdict, the bailiff will collect your notes and destroy them. Do not be influenced at all by my taking notes at times. What I write down may have nothing to do with what you will be concerned with at this trial. Admonition. I am now going to say a few words about your conduct as jurors. I'm going to give you some do's and don'ts, mostly don'ts, which I will call the admonition. Do wear your juror badge at all times in and around the courthouse so everyone will know that you're on a jury. Each of you has gained knowledge and information from the experiences you've had prior to this trial. Once this trial has begun, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about this case on your own. Do not view or visit the locations where the events of the case took place. Do not consult any resource such as a newspaper, dictionary, reference manual, television, radio, the internet, or any other electronic media for information. If you have a question or need additional information, submit your request in writing and I will discuss it with the parties. Do not talk to anyone about the case or about anyone who has anything to do with it, and do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, Twitter, instant messaging, iPhones, Google, Yahoo, or any internet search engine, or any other form of electronic communication for any purpose whatsoever, if it relates in any way to this case. This includes, but it's not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyer, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case or your courtroom experience with anyone whatsoever until the trial has ended and you have been discharged as jurors. Until then, you may tell people you are on a jury, you may tell them the estimated schedule of the trial, but do not tell them anything else except to say you cannot talk about the trial until it's over. One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts you find. As I previously told you, the only evidence you are to consider in this matter is that which is introduced in the courtroom. The law that you are to apply is the law I give you in the final instructions. This prohibits you from consulting any outside source. If you have cell phones, laptops, or other communication devices, please turn them off and do not turn them on while in the courtroom. You may use them only during breaks, so long as you do not use them to communicate about any matter having to do with the case. You are not permitted to take notes with laptops, cell phones, or any other electronic device. You are only permitted to take notes on the notepads provided by the court. Devices that can take pictures are prohibited and may not be used for any purpose. It is your duty not to speak with or permit yourselves to be addressed by any person on any subject connected with the trial. If someone should try to talk to you about the case, stop him or her or walk away. If you should overhear others talking about the case, stop them or walk away. If anything like this does happen, report it to me or any member of my staff as soon as you can. To avoid even the appearance of improper conduct, do not talk with any of the parties, the lawyers, the witnesses, or media representatives about anything until the case is over, even if your conversation with them has nothing to do with the case. For example, you might pass a party in the hall and ask what good restaurants there are downtown, and somebody from a distance may think you are talking about the case. So again, please avoid even the appearance of improper conduct. The lawyer and parties have been given the same instruction about not speaking with you jurors, so do not think they are being unfriendly to you. When you go home tonight and family and friends ask what the case is about, remember you cannot speak with them about the case. All you can tell them is that you're on a jury, the estimated schedule for the trial, and that you cannot talk about the case until it is over. In a civil case such as this, jurors are permitted to discuss the evidence during the trial while the trial is in process. During the trial, you're not to engage in any conduct that impairs or interferes with your ability to hear and understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you've heard and considered all the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you've had an opportunity to discuss the case with each other in the jury room at the end of the trial. Please advise me in writing immediately if you believe that any juror has violated any provision of this admonition. Before recess, I will not repeat the entire admonition I have just given you. I will probably refer to it by saying, please remember the admonition or something like that. However, even if I forget to make any reference to it, remember that the admonition still applies at all times during the trial. Media coverage. There may or may not be news media coverage of the trial. What the news media covers is up to them. If there is media coverage, you must avoid it during the trial. If you do encounter something about this case in the news media during the trial, end your exposure to it immediately and report it to me as soon as you can. If there are cameras in the courtroom during the trial, do not be concerned about them. Court rules require that the proceedings be photographed or televised in such a way that no juror can be recognized. Questions by jurors. If at any time during the trial you have difficulty hearing or seeing something that you should be hearing or seeing, or if you get into personal distress for any reason, raise your hand and let me know. If you have any questions about parking, restaurants, or other matters relating to jury service, feel free to ask one of the court staff. But remember that the admonition applies to court staff as it does to everyone else. So do not try to discuss the case with the court staff. If you have a question about the case for a witness or for me, write it down, but do not sign it. Hand the question to the bailiff. If your question is for a witness who is about to leave the witness stand, please signal the bailiff or me before the witness leaves the stand. The parties and I will discuss the question. The rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question and the answer is available, an answer will be given at the earliest opportunity. When we do not ask a question, it is no reflection on the person submitting it. You should attach no significance to the failure to ask a question. I will apply the same legal standards to your questions as I do the questions asked by the parties. If a particular question is not asked, please do not guess why or what the answer might have been. Presence of a deputy. Deputies are assigned to courtrooms by the sheriff's office. A deputy's presence in this courtroom should not be considered by you for any purpose, influence your view of the evidence, or impact your deliberations in any way. Alternate jurors. The law provides for a jury of 8 persons in a case such as this. We have more than 8 jurors so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, the alternate jurors will be determined by lot in a drawing held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of this case. Claims to be made and issues to be proved. Plaintiff's claims. 1. Fraud. Plaintiffs allege the defendants committed fraud in how they obtained access and control over the plaintiff's assets, including rental property located at 10124 West Ironwood Drive, Sun City, Arizona. Plaintiffs seek monies received by defendants from plaintiffs to hold in trust, from commissions and rents collected on rental properties. Plaintiffs seek a judgment restoring title to the Ironwood property plus money damages. 2. Consumer fraud. Plaintiffs alternatively allege the defendants committed consumer fraud in the manner they obtained access and control of the plaintiff's assets, including rental property located at 10124 West Ironwood Drive, Sun City, Arizona. Plaintiffs seek monies received by defendants from plaintiffs to hold in trust, from commissions and rents collected on rental properties. Plaintiffs seek a judgment restoring title to the Ironwood property plus money damages. 3. Quiet title. Plaintiffs claim the defendants acquired title to their rental property located at 10124 West Ironwood Drive, Sun City, Arizona, improperly. Plaintiffs seek ownership of and title to the Ironwood property as the true and legal owners. Defendants' counterclaim. Quiet title. Defendants allege the property located at 10124 West Ironwood Drive, Sun City, Arizona, currently titled in their names, properly belongs to them and should remain titled in their names. Scheduling during trial. The trial is expected to last 8 days, January 22nd through 25th, and January 29th through February 1st, 24. We will do our best to move the case along, but delays frequently occur. These won't be anyone's fault, so don't hold them against the parties. Delays usually occur because the parties and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I'm busy with other matters in other cases. The usual hours of trial will be from 9:30 a.m. to 4:30 p.m. We will take short recesses about every mid-morning and mid-afternoon and occasionally stretch breaks in place. We will recess at noon and begin again at 1:30. Unless a different starting time is announced prior to recessing for the evening, you may assume a starting time of 9:30 a.m. for the next day. At the beginning of the day, please assemble in the jury room for this division. Please do not come back into the courtroom until you are called by the bailiff. Order of trial. Trials generally proceed in the following order. First, plaintiff's attorney will make an opening statement giving a preview of the case. The defendants may make an opening statement outlining the defense immediately after plaintiff's statement, or it may be postponed until after plaintiff's case has been presented. What is said in opening statements is not evidence, nor is it an argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Second, the plaintiffs will present its evidence. After the plaintiffs finish the presentation of its evidence, the defendants may present evidence. If the defendants produce evidence, the plaintiffs may present additional or rebuttal evidence. With each witness, there is a direct examination, a cross-examination by the opposing side, and finally, redirect examination. This usually ends the testimony of that witness. Third, after all the evidence is in, I will read and give you copies of the final instructions, the rules of law you must follow in reaching your verdicts. Fourth, the parties will make closing arguments to tell you what they think the evidence shows and how they think you should decide the case. The plaintiffs have the right to open and close the argument since the plaintiffs have the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Fifth, you will deliberate in the jury room about the evidence and rules of law in an effort to reach the verdicts. If at least 6 persons agree upon the verdicts, they will be read in open court with you and the parties present. Finally, you will be discharged and released from the admonition. The rules of law I have shared with you in the past few minutes are preliminary only. At the end of the case, I will read and give you a copy of the final instructions of law. In deciding the case, you must be guided by the final instructions. Also, I wanted to let you know I'm very casual with regard to any food and drink you want to bring into the courtroom. You're welcome to do so. Just be mindful of the sounds and smells for your neighboring juror. Also, if you need to stand and stretch at any time, you're welcome to do so. All right, at this time, the parties will be permitted to make their opening statements. Again, what they say in their opening statements is not evidence. It's simply an outline of what the lawyer or the party believes the evidence will be and is offered to help you understand and follow the evidence during the trial. Plaintiff, are you ready to proceed?
Yes, Your Honor.
Defendants, are you ready to proceed?
Yes.
Thank you. Plaintiff, you're welcome to proceed with your opening statement.
Thank you. May I show the slide presentation I have?
You're welcome to do so.
I'm going to have some notes up here that I'm going to...
Please use your microphone so they can all hear you, okay?
Thank you, Your Honor.
Yes, sir.
I have a slide presentation that's going to have some notes up here, so I'll be talking both off of those notes and on those notes as well. So thank you, first of all, for being here and giving us your valuable time and consideration in this matter. You're going to help us decide this dispute, and we appreciate your time and very much your commitment to civic service. Greed, money, and deceit. This case you're about to hear involves all these. Unfortunately, it is not just part of a fictional TV show or a movie. What you will hear in this trial really happened, and it really happened to a very kind, compassionate, caring, elderly couple who were targeted and exploited by the defendants Nicholas Cassavelli and Nicolina Castelli. Let me introduce to you Miss Donna Johansson. She's seated here next to me. She is one of the elderly people who was exploited. Her husband, Gary Johansson, was also exploited along with her. He is deceased. Unfortunately, Mr. Johansson passed away from a diagnosis of Lewy body dementia and is no longer with us. So Ms. Johansson is actually representing him through his probate estate. in which she has been appointed as the personal representative in order to bring his claims for what occurred to him while he was still living. Gary and Donna Johansson are suing the defendants, alleging that the defendants took a large amount of money and a house from them impermissibly. The defendants deny that they did anything wrong. Through this trial, each side will get to tell their side of the story. You as the jury will decide who is more believable and credible, and ultimately whether Gary and Donna have proven their claims and whether they get their money back and their house back. The evidence will show, in our opinion, that Gary was a respected executive director at the Washington and Jane Smith Home and Assisted Living Center from 1980 until 1920, or from 1980 to 2002, after which he retired. Evidence will further show that he had a wing at that home named in his honor and a street in Chicago named in his honor as well. The evidence will also show that Donna Johansson was a dedicated third-grade teacher who served in that capacity for over 40 years educating our community's children. The evidence will show that these two caring people were taken advantage of by the defendants and defrauded. The evidence is going to be talking about 5 different kinds of assets that were taken. The first one is $127,649.09 in cash in January of 2017. The evidence will show that the defendants are claiming this was given them to purchase their LLC, but their LLC was completely worthless. What you will hear from Donna and from our expert witness is that this money was actually believed to have been given to the Casavellis, the defendants, to hold in trust so that they could protect it from a nephew they asserted was after that money from the Johanssons. The Johanssons thought this money was always going to be theirs, and that the document they signed saying they were purchasing the defendant's company was actually just a kind of a cover to that transaction to keep the nephew at bay. So we're going to seek to get this money back as part of what we're going to prove. There was also a house located at 10124 West Ironwood Drive in Sun City, Arizona. This is a home that was being rented by Mr. and Mrs. Casavelli. Towards the end, or towards around March 2017, we believe that they caused a document to be signed by Gary and Donna Johansson that was not fully explained to them about what it was. In fact, the evidence will show that they were only provided the second page of a quitclaim deed. The first page, which said quitclaim deed, was not provided to them at the time that the document was signed. Gary and Donna Johansson believed that they were signing something related to a legal matter they were dealing with, and so they signed the second page unknowingly and unwillingly and did not mean to convey or transfer the property to the defendants. A third asset we're going after is rent on the Ironwood Drive property for 79 months at $800 a month, totaling $63,200. This is the rent that the defendants would have paid from the time they took title to the house in July of 2017 up until January of 2024. They have resided in the house continuously since that time, and we are alleging that the Johanssons deserve to have that rent paid, and it totals $63,200. The fourth asset that we're claiming that needs to be paid back to the Johanssons are impermissible commission payments from the sale of rental properties, totaling $42,960. These rental properties, there were 5 of them, were sold in 2016 and 2017. The defendants offered to help assist with the sale of those properties, and they are not licensed real estate agents. And they proceeded to receive and ask for a commission of 6% on the sale of those properties, which they were not entitled to. The Johanssons paid it, but they did not understand at the time that they were not permitted to receive commission payments as a normal real estate agent would. So we're asking for a return of that money. And then 5, we're asking for the unaccounted for rents that the defendants should have turned over to the Johansons for the rental income they collected. The defendants offered to serve as property managers for the Johansons. Again, property managers, the evidence will show, are not permitted to receive payment when they are not licensed as a real estate agent. But they claim to have taken compensation, and then as they collected the rents from the Johansons' rental, from their tenants, they would take the money into an account through their LLC and then transfer it to their personal account. The evidence will show that they took in the neighborhood of $81,664.62 that was transferred from the rents to themselves personally and was never received by Gary and Donna Johanson. The legal claims that we are asserting by the plaintiffs in this case are numerous. You are not going to be deciding all of them. You are deciding 3 of those claims: fraud, consumer fraud, and quiet title. The rest of the claims that are listed up here are going to be claims that are tried to the bench. In other words, the judge will be deciding those claims. But you will hear testimony about all the claims together at one time. So some of that testimony may be relevant to your claims that you'll be citing, some may not. But please pay attention to all the testimony that's given, because some of it is overlapping and will play out in different ways. And so we're asking for the court to decide a claim called financial exploitation of a vulnerable adult, then undue influence, constructive fraud, constructive trust, unjust enrichment, breach of fiduciary duty, and equitable mortgage, declaratory judgment, and accounting. Again, you will not be asked to render a decision or a verdict on those claims, but you will hear testimony about those that may very well be a part of whether you decide that Gary and Donna Johanson were defrauded under the fraud and consumer fraud claims. You'll decide, and whether or not they should get their house back. So please pay attention to that. In particular, you're going to hear from an expert witness named Dr. Pamela Wilson, who's going to testify that Gary was a vulnerable adult at the time all of these transactions took place, and that both Gary and Donna were susceptible to undue influence at the time that all of these transactions took place. And I got ahead of myself, and so here there's the legal claims that you'll be deciding: quiet title, fraud, and consumer fraud. And for all of these claims, we'll be asking for those 5 assets to be returned to us, except for the quiet title. The quiet title action will only apply to the house, because it can only apply to the house. It can't do anything about the other money that was taken by the defendants. The claims that we have pled are in the alternative, meaning that we would like to have you render a judgment for each one to the maximum amount that you believe should happen. We will not be piling on where if you give a judgment for fraud over here and the judge gives a judgment for financial exploitation over here, that they're going to be added together. Instead, just the highest amount for each of those categories will apply as a judgment. So there'll be one judgment on those 5 assets, regardless of whether you find the defendants guilty on more than one claim. I hope that makes sense. What the evidence will show for the first asset, we believe that what you will hear is testimony from Donna that defendant, pardon me, having a little trouble with my PowerPoint, that the defendant Nick Casavelli led Gary Johanson into believing that his money might be taken by a nephew. You will also hear testimony from Donna that the defendant Nick Casavelli came with a quote-unquote strategy to help Gary protect this money, which involved giving the money to the defendant Nick to hold, but that the money would always be Gary's and would be returned upon request. You will also hear testimony from Donna about defendant Nick Casavelli proposing to disguise the transaction as the purchase of his company, a company called Aspire LLC. LLC stands for Limited Liability Company. You will also hear Donna testify that Aspire LLC had little or no value and was not equivalent in any way to the $127,645.09 turned over to the defendants when they signed that document. The second asset is the house appropriated by the defendants from Gary and Donna Johansson. The evidence will show that the defendants prepared a quitclaim deed to sign over to them the house they were renting located at 10124 West Ironwood Drive. You will hear Donna testify that the defendants slipped in the signature page of the quitclaim deed only with other documents they were given to Gary and Donna to sign without providing the first page of the quitclaim deed and without explaining what the signature page was for. This will be backed up by the testimony of the notary who actually notarized the witness page. You will hear Donna testify that she and Gary did not know the signature page had been slipped in and never intended to sign over the house to the defendants. The evidence will also show for the third asset is that rental money the defendants should have paid for use of the house they impermissibly took from Gary and Donna. The quitclaim deed, you'll see, the evidence will show, was signed on or about March 30 of 2017 and then was held by the defendants until July of 2017. In the interim, Gary and Donna Johansson did not know that they held a completed quitclaim deed and did not know that they were going to ever file such a thing. When they recorded the quitclaim deed in July of 2017, they proceeded to quit paying rent on the property, and their rent at the time was $800 a month. That rent has not been paid from July 2017 until now January of 2024. That period of time is about 79 months times $800 a month. So will be asking for a return or a payment of $63,200, which is just simple math. 79 times 800 will equal that amount. The fourth asset that we'll be asking for you to give a verdict on is the impermissible commission payments received by the defendants in regard to the sale of Gary and Donna's rental properties. The evidence will show that defendants are not licensed real estate agents. The evidence will also show that the defendants attended real estate school, and so they should have known that they were not allowed to proceed to act as real estate agents without a license. The evidence will also show that defendants, at their suggestion, were paid 6% on the net proceeds from the sale of Gary and Donna's rental properties. There were 5 of them. The evidence will also show that the defendants were paid $42,650 in impermissible commission payments for the 5 properties that they purportedly helped sell. The last asset are rentals that they collected from the tenants that were residing in the 5 rental properties that Mr. and Mrs. Johansson had rented out. These monies were collected, and we will produce bank records showing the collection of those rental monies. And we will also show bank records showing those rental monies being transferred out from the Aspire LLC account, which they used to collect the rental monies from, and then they transferred it into accounts that they owned personally. The evidence will show that they were also not licensed to serve as property managers, which also requires a real estate license. The evidence will show that the amount that they took over that period of time was about $64,864.62 that we've been able to locate. In addition to that, During the time they served as property managers, they didn't collect rent from themselves on their own property. That rent, calculated at $800 a month, ran from October of 2015 through June of 2017. And that amount comes to $16,200 that we're seeking. So we're showing here a combined amount of approximately $81,000 that they either collected in rents from the tenants and failed to turn over to Gary and Donna Johansson, or rents that they should have paid as part of their rental and did not collect and should have if they were properly doing their job. We're going to be talking a great deal for some of the other claims about Gary's vulnerability. You're going to hear a lot of testimony from Dr. Wilson about how vulnerable Gary was. The evidence will show that Gary suffered from a condition known as Lewy bodies dementia from as early as November of 2015. The evidence will show that due to the Lewy body dementia, Gary could not protect himself. The evidence will show that the defendants were in a fiduciary and or confidential relationship to Gary Johansson. The evidence will also show that the defendants exploited Gary Johansson while he was a vulnerable adult and while they were in a position of trust and confidence. The evidence will also demonstrate of the need to return all assets that were appropriated from Gary while he was under that condition of vulnerability. And we're going to be asking for those assets to be returned with statutory double damages, which are allowed under the statute. And the reason we're going to ask for the double damages is because of the continuing and intentional amount of assets that were appropriated by the defendants over a long period of time. And we believe statutory double damages is a way to make the Johanssons whole and a way to send a signal to the defendants that their conduct was incorrect. Under the fraud claims, you're going to have a chance to also do what are called punitive damages. Punitive damages are just what that sounds like. They're made to punish. And we're going to be asking for punitive damages under the fraud claims that would be equivalent to the statutory damages that we're asking for under the financial exploitation clause. So when you hear us give estimates about how much was taken under the financial exploitation clause and the double damages there, that is what we're asserting we would like to see awarded as punitive damages under the fraud claims. What the evidence will show about Gary and Donna's susceptibility to undue influence. Undue influence is a separate claim from a claim for financial exploitation, but they're often treated in the same kinds of circumstances. And so here we will hear evidence that will show that, again, Gary suffered from Lewy bodies dementia from as early as November 2015, causing him to be, during that entire time from November 2015 to the end of his life, to be susceptible to undue influence. You will hear a very well-known and very accomplished neuropsychologist that will be testifying in regards to both the vulnerability issue and to the undue influence issue. The evidence will show that Donna was also susceptible to undue influence, again, as stated by the expert witness. The evidence will show that the defendants were in a fiduciary and or a confidential relationship to Gary. That is going to be important because, and to Donna. That is going to be important because being in that kind of relationship puts an extra burden upon the defendants to show that anything they did was for the benefit of the person who they took the money and the property from. The evidence will show that also that the defendants were unduly influenced Gary and Donna in appropriating the 5 different assets that we talked about a moment ago. What the evidence will show about the quiet title claim. The evidence here will show that Gary and Donna owned the property at 10124 West Ironwood Drive in Sun City, Arizona, and that it was completely paid for by them, not by anyone else. The evidence will show that Gary and Donna were tricked into signing a quitclaim deed by the defendants. And the evidence will show that the 10124 West Ironwood Drive property should be returned into the ownership of Gary and Donna Johansson and or their company that they may have had that in before. What the evidence will show about the fraud claims. The evidence will show that in furtherance of their fraud, the defendants made representations or omissions that were false and material. The evidence will show that defendants knew these statements and omissions were false and intended for Gary and Donna to rely upon them. The evidence will also show that Gary and Donna did not know that the defendants' statements and admissions were false. And the evidence finally will show that the defendants' conduct was intentional, deliberate, and egregious, such that punitive damages should be awarded. It's almost time to hear the evidence. As soon as I finish up, you will get to hear the defendant's opening statement. After that, testimony will begin, unless, of course, we break for lunch. As a technical aspect to getting the evidence admitted, Gary and Donna will need to bring in persons who will be laying foundation and to authenticate some documents that we're going to be submitting as documentary evidence. We will be opening up with those persons, and it will be a bit dry as we go through that process to get the documents admitted. But those documents are critical for showing and proving our case. So bear with us while we get to our expert witness, Dr. Wilson, and to Ms. Johansson as quickly as we can. Also, please note that because of scheduling with the witnesses, we may have started with one witness and we may have to ask the court for permission to take somebody out of order. So if I have Ms. Johansson up on the stand, for instance, and somebody has a day where they can only be here that day, we may interrupt her testimony in order so that witness who had a scheduling conflict can be here with us to testify. And we hope that you'll be able to still pull all together the evidence that's being offered by whoever is interrupted. Beyond that, thank you for being here. Thank you for helping us out. And we appreciate all that you're doing, giving up your time to be here with us. Thank you.
Did you wish to proceed with your opening statement? You may proceed.
May I?
You may, absolutely. Yes, sir.
Well, you all heard Mr. Easton's prescriptive statement. Why not convict me right now? I'm a horrible person, according to him. He's had 8 years to write this stuff. Most of it is not true. Most of it doesn't even relate to the events that took place.
Can you all hear him okay? Okay, good. All right.
We'll try to address his issues that he come out with one at a time. First of all, he put words up on the screen that's not even true. Okay? And now he read them, because I've seen everybody looking at it. Okay? He said that Mr. Johansson died in 2021. But they alleged that Mr. Johansson died in 2019, was it not? So he's misleading you. Because in 2019, when they said he was dead, maybe Mr. Johansson wasn't dead at that time. But that's been an issue that we've been arguing with all this time. Next, says Ms. Johansson taught school for 43 years. Ms. Johansson didn't teach school for 43 years. Ms. Johansson taught school for 6 years, as she told us, in confidence. And back in the day, or 12 years, I'm sorry. I stand corrected, Ms. Johansson. Okay, so then we go to $127,000 that we supposedly took. Now, please pay attention, because this is going to be really interesting for you. I hired this man. For the LLC, me, Ms. Johansson is a member.
Objection.
And her husband is too. I hired him.
Go ahead, continue.
I hired him for issues with the LLC because of being a member. Their issue comes up with the LLC is a rental house company. Okay. Yes, they own the assets to the Garpdon LLC. I do not. I never claimed to. I didn't take proceeds. I was hired at an hourly rate, as evidence will prove. There's a recording where actually Mr. Easton is
Counsel,
pushing-
I'm sorry, pardon me, you approach? White noise. Judge Blanchard ruled against that recording, so
No.
reference that recording.
No, it's in motion limit. He allowed it.
Mr. Norman, number one, he allowed that.
He allowed that.
Let's pull them out.
He allowed 3 of them.
Let's make sure that we're referencing the right ones, okay?
It's a January 23rd conversation, Commissioner.
No, section
January 23rd of 2017. He did allow it.
No. January 23rd.
January 23rd, 2017.
Okay, I know my date's different. Too many numbers.
If you have access to the docket, it's on the ECR docket as well. He had ruled because they had voluntarily given a copy of the recording. They had waived any
They
type.
waived it, yeah.
So the one that we can't reference,
There's actually 3 of them that he ruled against us for, and Mr. Easton and Johansson's. Number 1 was a January 23rd
so we
conversation.
have the recordings that described on January 23rd. Is that the one that you're referencing right now?
Yes.
Okay. Finds that the attorney-client privilege, if any, at the conference on January 27th as described in the motion was waived and plaintiffs agree, so you can refer to that one, but there's another one in here that you can't.
There was some,
Here we go.
The second one, he
it
allowed.
was in December of 2018.
Okay, so don't reference, you can reference the January 23rd, but don't reference the others.
Okay. Well, there was 2 sets in December, though.
One was
And he
the
was referencing
subpoenas.
the ones later in December of 2018. But there was some on November 30th and December 1st conversations that was recorded, that submitted. But it was one where we were discussing with them. They wanted to discuss
Only the ones on
settling
the
this whole
18th
issue.
of December were
Okay,
not
only
allowed.
reference the January 23rd right now.
Okay.
All right, thank you. Go ahead.
This is what I brought up on Friday, though, as re-urging or motion to reconsider on that ruling, because, again, they were in a fiduciary relationship at that time. They were acting as agents under a power of attorney.
No, Your Honor, we were not.
You're going to have to prove the fiduciary relationship before I'll reconsider that. So at this time, it's denied. Okay, go ahead. Thank you.
It's just-
You can turn it off. Go ahead and make your argument. January 23rd is okay.
Thank you.
Yes, sir.
As stated, there's a conversation of January 23rd of 2017 where Mr. Easton is talking with the Johanssons about these very allegations right here. None of these allegations were at that point in time. Okay. That conversation totally disproves every claim that he is claiming against us, because what he stated to you is not even close to being accurate. What this case is about, whether you know it or not, is basically a partnership in a business that went wrong because of bad legal advice an attorney give to members, which is to take money from their vulnerable sister-in-law to close down a irrevocable asset trust, to award the money to themselves. And then when a criminal investigation ensues after this action takes place, what best way to get your clients out from underneath a lawsuit unless you can file a lawsuit claiming vulnerability? Well, this is exactly what he did. The lawsuit is frivolous at best. There's no proof. Most of it's already been disproved throughout the last 8 years of litigation. So what we have is him claiming things that we're such horrible people, when in actuality it's a claim about attorney giving clients bad advice, causing a criminal investigation on them, filing a frivolous lawsuit to get them out of which the evidence will prove, to get them out of a lawsuit. Now, did it work? Sure did. 10 days, 11 days after the lawsuit was served and filed on our attorney then. The investigation was dismissed against Gary Johansson for financial exploitation of a vulnerable adult, his sister-in-law. Was that good? Should have been good. Due to the allegations, though, Mr. Easton decided to continue the litigation, preparing for his son's college. He discovered that Mr. and Miss Johansson had assets. Mr. Easton decided to go after those assets and has. $600,000 in attorney's fees. I know because that's cost me almost $400,000 over the last 8 years. $600,000 the Johansson have paid. Not to me. To the point where even Mr. Johansson accused Mr. Easton in a position of financially exploiting them. Not me. I asked the question. I asked Mr. Johansson directly, have you ever been exploited? He states he's paying high attorney fees. That was a loaded shotgun to point right at me and say, you've done it. He didn't. I didn't. Did I have access to their accounts? Some. Did I touch them? No. Why? I'm not that type of person. But according to him, I'm a horrible person. And you should take everything I own and make me be in debt for, I can't even add that high anymore. Not without a calculator. The truth of it is his vendetta. See, this case made him partner at a law firm. And I believe this case also took that away from him because of events surrounding this case. The evidence will prove to you that there was an operating agreement, I am a member, and that any and all claims by them is not true. You do not need a real estate license to be a managing member in an LLC. It's not illegal to be compensated for working at a company. This is all provable. The assets he's talking about is rents. The rental homes were owned by Garp Don LLC. The Johansson's income taxes shows they collected the rents. Every bit of it. Irrespective of what trail that he's trying to make, okay? They collected the rents. They sold the homes. They collected the proceeds of the homes. Of course, I helped through the LLC because that's what a member does in a partnership. It's not illegal. Was that compensated? A little bit. Did we remodel the homes? Yes. Did they pay us for the remodel? No. And that's where the burden Mr. Easton has come up with. We're going to have some creative bank records, which they're subject on that too, because see, there's some creativeness on those documents and questions about it. If they should, the commissioner should rule on evidence of that, whether it's going to be allowed or not. And you'll hear us object to every one of those financial documents, because those documents that he's going to produce in bank records, there are tax records that completely refute those documents. So his twisting and turning of the truth and the evidence that he's saying presented to you, okay, won't be accurate. The evidence will show that. When it comes to the expert witness, this is a good one. The expert witness spent about 30 minutes with Ms. Johansson and Mr. Johansson and suddenly determined who's what, who's who, and if they're vulnerable, if they're, well, I don't know, influenceable, susceptible, whatever word he'd like to use. And the fact of it is that they paid. They paid for the expert witness to render this opinion. Okay. Now, to me, you kind of got to take that with what it's worth. Okay. And you must understand, the expert witness never spoke to us, but yet rendered an opinion about us. Only through information provided by the attorney I hired, who uses the information he gained from the LLC and the representation to file a lawsuit against my wife and myself, because he thought we were easy targets and the type of people we'd just walk away and not fight. This isn't about the money. This is about honor and reputation and truth. I have integrity. And I would be honest with you. If I took their money like he said, I wouldn't be here. I never would have showed up. I wouldn't have fought for 8 years now. The truth of the matter of it is, his deeds, his bringing this without standing in the state of Arizona through an assignment from an LLC, which is provable, which he couldn't even get that right because he kind of forged that document too, I do believe, because the LLC is wrong. Right? The trust is wrong. The information on the document is wrong, which it took him a year to produce. The expert witness. What does she know? Does she know her field? Probably. Does she know me? She ever met me? How can she render anything about me if she's never met me? To say that maybe they are vulnerable? Well, aren't we all to some point? Depends on what your idea of vulnerable is. They claim Mr. Johansson worked 43 years, was it? You stated? In the, no, that was Miss Johansson. I'm sorry, I got that wrong. You didn't say how long he was a CEO, but you failed to mention that he was a CEO of a assisted living home in Chicago, where he controlled everything. So he knows the ins and outs of vulnerability about people, which is a different story. The evidence will turn that up later. We come back to then the alternate claims. They're asking you to render a verdict on alternate claims. But if you remember hearing the commissioner, those would be decided to the bench. Now, I don't know why he's asking you to render a verdict on the financial exploitation and everything that's not being heard other than the 3 claims that they ask you to render a verdict on. But that's meant to influence you, to show you that I'm a horrible person. And for him to try to prove to you that I'm this monster standing before you. I'm a human being just like anybody else. The only difference is I hired the wrong attorney. That's the issue of it is. Ms. Johansson, I'm probably going to testify. Are you not Ms. Johansson? Are you going to testify in this trial?
You can't ask questions, so you can just present your case.
Well,
go ahead, just present your opening statement. Thank you.
We were not allowed to take Ms. Johansson's deposition, so I cannot refute her testimony. So whatever she says is pretty much what we know. I don't know why. Other than every time we tried 9 times to take a deposition, we were blocked by the attorney I hired for the LLC.
Objection, Your Honor. Move to strike.
Sustain.
He said that there was an agreement in his well-scripted little PowerPoint that holding money was an agreement that it would always be safe. This question was asked by him in Gary's deposition. Even Gary stated then, no. See, I do happen to think that's somewhat illegal to try to hide assets for some reason, whatever reason. That was asked to Gary. He said no. There was no agreement to hide money, hold money, or anything like that. The bottom line of the purchase of LLC Aspire he's talking about, $2,000. $2,000 is what it returned. As Gary admitted in his deposition, of the $127,000 that Mr. Easton claims we took, Gary testifies in his deposition that $125,000 was returned to him. That doesn't account for $127,000 for what you call a worthless LLC. But yet, it does show that he did receive money. And yet, where did the money go? To a bank account that we didn't have access to subpoena because it was blocked. It was a Wells Fargo account. The Johanssons have multiple bank accounts. At least they did then. I didn't have access to them. Neither did my wife. Yet, we're accused of being horrible people. I get it. Because why? They're the plaintiffs. They want you to rule against me. They want you to do it. If you believe that, please don't spare the verdict. Tell it now. Tell the judge here that you wish to render your verdict against us, and it'll spare us all a bunch of problems. Instead of sitting out and listening to some blood-drying urinary reports or diabetes reports of what type of food Gary ate or how much human log he had to take or this kind of thing. And when it goes to, basically, that it's going to go through 7 years of medical reports that isn't related to vulnerability or Lewy body disease. There was never a definitive diagnosis of Lewy body. If you count a medical assistant, which is, you know what a medical assistant is, that says that Gary's under her care and his signatures shouldn't be considered as being valid. I don't see how that's accountable, but that's some of the records they're going to produce. Rents owed? No rents owed. The subject house on quiet title that you are here to render a verdict on. It's my home. I worked for it. The Johansons know it. The evidence will prove it. The evidence that's before you and will be put before you is something simple. It's not complicated. Did I sign for the selling of the homes? Yes. My name is on every warranty deed. How does my name appear on a warranty deed? Not through a power of attorney. Because you can't use a power of attorney for an LLC. You have to be a managing agent member, which is exactly what happened through unanimous agreement. The Johansons made me a member, and I accepted. So that way I could sell the properties. You don't have to be a real estate agent to do this. But you do have to be a member of the company. Now, they're going to argue that I'm not on the Articles of Incorporation. Of course, then there's Arizona laws that will apply to that, that you don't have to be on the Articles at the time of formation. Their formation of the company, I believe, was 2011. Through an operating agreement, anybody can become a member of LLC. Just like a lawyer can become a member of his firm through an operating agreement. The same happened here. There's an operating agreement that Mr. Easton don't want to recognize, but it's there. Managing member? Yes. Commissions? No. Commissions would be to a real estate agent. Payment for selling the properties? The owners of the properties, Johansons, being members and managers of the LLC. That they did agree to. I didn't set no price. Audio recordings, videos, things like that will also tell you the same thing. I know, this is dry and boring stuff, isn't it? It is to me because I've been over so many times. Okay, so you're to give a verdict on equitable claims, which I don't understand if you're not going to be hearing those, but you're going to hear them anyway because they're mixed in. We can't just have two separate trials, which would make more sense. So payments from Garbdon LLC, to me, if any at all, is what you will see. Not payments from the Johansons in a personal capacity or anything that I took from them that they're saying. They can't show anything. When Mr. Easton filed this case, Arizona law requires a copy of it go to the Attorney General's office, especially when you allege financial exploitation, which is exactly what happened. He did when he put that in there. So the Attorney General's office gets it, forwards it over to Adult Protective Services. Adult Protective Services then conducts an investigation. And the evidence will show that Adult Protective Services did not substantiate exploitation. None. And dismissed it. Now, there was other documents that was brought into it. The investigator did not tell us what documents. We subsequently found later it was a complaint filed by Mr. Easton and copied to the Attorney General's. In there, you have an expert witness that's going to testify that says that this investigator made mistakes. This investigator, Adult Protective Service, didn't make mistakes. She went off the information that was filed in a complaint by Mr. Easton, who intentionally listed the wrong subject property to send to Washington State to terminate a criminal investigation against the Johansons. That's what he did. Then they refile, and well, this was brought to the court's attention, and a notice of errata was to change the house. That's not even that important of a thing. Again, any alleged monies they're talking about rents collected, any rental income that the LLC homes generated, the Johanssons claimed on their taxes from 2016 to 2017, or 2015 to 2017. It's there. Maybe 2017 they didn't. He claims I'm a property manager. They acted as property managers. No. I was a, what do you say it? I was a member of an LLC. I was a managing member of an LLC. I also was the worker of the LLC. Obviously, Mr. and Ms. Johansson cannot do the work. At their age, at that time, even 10 years ago, even 20 years, they probably didn't want to do it. Okay? I'm not quite as old as them, but we did the maintenance and the repairs to prepare the homes for sale. Where the Johanssons collected the proceeds, not us. Now, if we were going to exploit someone, do you really think we'd still be here? We'd have grabbed that money and ran, right? Because that's what anybody would do if that's what they was going to do. But that didn't happen. We never accessed the money because we didn't want to be on the account the money went into, which was the LLC account. There's no access, so there's no money taken. He's claiming $16,200 not claimed. This is a new claim. Money I never heard of. In 8 years, he has never took the time to explain to me how $16,200 comes up to this. So we have, back to Ms. Wilson, who's going to testify about things that 30 minutes will reveal in a person. I think each and every one of you right now have a better idea of us, even no matter what you was told prior to being selected as jury, but you have a better idea about us now than you did 30 minutes ago. You have a better idea of the situation in just less than 20 minutes. Okay, whether you believe this or not, there's evidence to support statements. They claim a fiduciary relationship. Technically, there is. But the only fiduciary relationship that can be proven here is between members of an LLC because they have a fiduciary relationship to each other as business members and partners. Not what you're going to be shown here, which is a intentionally forged power of attorney that wasn't even used. Or two of them. One of them wasn't even signed. How do you use a power of attorney that's not signed? Not by me. I didn't sign it. I didn't use it. There was no need to. In fact, Old Republic Title is the one who actually drafted the operating agreement for Gartendon LLC. It wasn't me. Nothing to do with it, or my wife. We didn't defraud anyone. We didn't make anything susceptible. We didn't hide anything. And then here it comes to alleging a quick claim deed. The last page was submitted. And I think you said it was a stack of papers for sale house property, but that's not it because, see, there was no houses sold after that. They had sold the last house they was going to. With the quick claim deed, we, my wife and I, remodeled 7 of their homes to prepare them for sale. The Johanssons were upside down on their personal homes and their mortgage. The first property sold was in Phoenix, on Granada Avenue. In fact, they sold it and they paid off one of their mortgages, their second mortgage. We didn't touch the money. We didn't prevent it. Now here, if you have access to $750,000, hey, why sit and try to collect someone's rents that they admitted they have and collected on their taxes? Why would you do that when you could just easily grab the $750,000 and just go? I mean, what, Caribbean, Bahamas? No, we're here. That's not us. We didn't do this. But we're horrible people according to Mr. Easton. And why? He wants you to know we're horrible people because he's using attorney-client privilege against us. There's recordings that will prove that. These issues that you're going to hear in here, there's just one recording on January 23rd, 2017. It's going to make you doubt if any of it's true at all that he says. He wanted to hire us in that recording. The Johanssons had nothing to say bad about us. In fact, they actually give examples how good we were. We didn't demand payment from them. Did we keep track? Yes. The hours worked? Yes. Did we deny payment? No. So how does the house come into this? When they sold the last house, Gary said, the only ones that didn't get paid is you. They gave the quitclaim deed for payment. The house was purchased for $80,000. They owed us more than that for remodeling 7 houses. Our money went to that. Now, there's some creative bank records that says rents were taken, but in the end, you have to look at the evidence of the tax records. The Johansson's tax records is what's going to prove to you they received the rents. And none of it's true, that we took anything. If anything we took was given, not taken, you can't take what's offered. That's the bottom line. Here, they're saying that the Johanssons paid for the subject property, our residence, 10124. Yes, they did. And they had every right to give it away for payment and services that we performed that made them $750,000. And to sit and have basically payer's remorse is what this is. Okay? Because why? An attorney I hired who uses attorney-client privilege information against me to make these horrible allegations scripted, which you can count on. Expert witness, in my opinion, will have the same scripted answers. So how is it illegal for a partner in an LLC to manage a business when they have consent from all parties, all members? How's that illegal? It's not. Is it illegal to get paid and compensated in some way? But not through the sales of the properties, but by what the Johanssons paid as a member. I didn't claim ownership of any of the properties just because I'm a member, which would have been 1/3 of the property of the amount. Would have been $250,000 if that had been the case. I didn't ask that. We didn't ask for anything. We accepted what they offered. We didn't take. So to say that they're the ones who purchased the house originally, that's irrelevant. It's what they did with the house willfully, knowingly, and intentionally after they purchased the house should be considered, which the evidence will prove. As for Lewy body disease, they claim Mr. Johansson had. No legal diagnosis, no official diagnosis from any of the medical reports. In fact, most of the medical reports state that no official diagnosis. Not even with Alzheimer's. There was alluding to Alzheimer's, maybe, because of age. I think we're all going to forget something when we're in our 70s. I'm in my 60s now, and I forget things. I imagine it's only going to get worse as we get older. Okay, so that doesn't mean that you're susceptible, vulnerable, or that you've done anything illegal. Helping somebody and working with them as a partner and doing your part without exploiting them doesn't mean you exploited them. Proper compensation, well, everybody thinks their idea what's proper is proper. I might think a car is worth $1,000. Somebody else might think it's worth $50. Depends on the type of car. Rolls Royce, they can sell for $500,000. I think it's a little bit much, but it's a nice car. But again, it's on perception. So you have to go on the evidence of what you're going to have here. The majority of what he's going to present to you is going to bore you, and you probably won't remember half of it. But he's going to drive home that we're horrible people and that we exploited these people. We lived 7 houses from Ms. Johansson. Ms. Johansson's had a few problems along the way of this litigation. She actually told us about when somebody tried to set her house on fire. I feel bad for Ms. Johansson, but I can't help Ms. Johansson anymore because why? There's a lawsuit. I feel bad that things happened to her. I feel bad that through this lawsuit, she pretty much doesn't get to see her grandchildren or son. But it's not my cause. It's the allegations that Mr. Easton has done here has pretty much offended her family from her. Now her children are almost grown, her grandchildren are almost grown. And it's sad because that's not like this. Gary Paul Johansson's on the witness list. That's her son. He wasn't involved in any of this, which he should have been. And he was aware of everything. And yet, he doesn't allege any of this. In fact, he was consulted on several occasions about certain things about the rental properties, in his opinion. And it was adhered to. No one went against Gary Paul Johansson's wishes. Nobody did. In this here, you're going to hear all types of evidence. And ours is minimal, because the burden of proof is upon Mr. Easton and Johansson's. But keep in mind, he's going to keep driving how hard it is and things you're not really supposed to render an opinion on, if I'm correct. Claims and equity goes to the bench, correct?
Correct.
So he's telling you to pinpoint those things that he's going to say, because he can convince you that these claims in equity, he's saying like financial exploitation and I don't even know the whole laundry list of them. But if he can convince you of that, it's going to be easy for you to render a verdict on quiet title and the other consumer fraud and fraud, which I've asked him for 8 years to explain to me the fraud part. He hasn't done it, so that's why I was writing down his notes. A lot of this is new, his allegations, because he don't talk, he don't give, he don't disclose. So we're here to surprise for us today. And keep in mind, the judge said this isn't testimony, this isn't evidence, this is just a statement of the case. And this is what the case is about. This is a case about, from the beginning, we did move to Sun City. We did rent from the Johanssons. We wanted to see if we liked the community, like anyone would do. So we rented. It was okay. The street we lived on wasn't that good. Had a few problems with people over there. Dogs. Trying to burn the house down by, say, killing scorpions on the front porch. Things like that. Just crazy stuff. So when another house came available, we asked them if we could move over. They said, sure. But there was a condition attached. The condition was attached that we could rent 2 of their houses. We told them we're not real estate agents. Mr. Johansson acknowledged that to Mr. Easton before filing his complaint. And he ignored it and still put it in the complaint. Even when he amended the complaint, he still put it in there. We never claimed to be real estate agents. Never. We never acted as real estate agents. The evidence will also show that Department of Real Estate complaint was made. Even they understood we weren't real estate agents. And we wasn't acting in that capacity. There's evidence to prove. So we moved to this house, subject property, 10124 West Ironwood. Did we rent the other 2? Yes. We rented them out within 10 days at a higher rate than they were getting than they asked for. Okay? Is that wrong? We never confessed or tried or even stated we was. Maybe we shouldn't have rented them out for them. They were in Minnesota. What was we supposed to do? They asked us to. We didn't think it was going to break any laws. Still don't. So, after we moved, those houses were rented. I believe there's a flood happened to one of the rental houses, of Gartner's rental houses. They hired a restoration company to come in. They were there one day, and a $10,000 bill was attached to the property. We discovered that they were unlicensed contractors, but they had let their license expire. We brought it to their attention. Complaint was made. They were asked to remove from the job before they did more damage. They did. Mr. Easton tries to take pre-litigation fees from that, but he didn't do any of the work. Okay. We pointed out that they were damaging the home. The Johanssons need to get someone there reputable to fix the home. They had wood laminate floors. They were damaged big, bad. They had a couple opportunities offered. One of them couldn't get to it for 6 weeks. It was rented. Tenants were in there. Back, one of the witnesses, Christopher Adams, he'll testify.
Excuse me, would the parties approach right quick? White noise. Thank you. You're at 35 minutes. You both have 35 minutes for your opening. How much more do you? Because you're cutting into their lunch hour right now, so I'm going to extend their time after. So they have a longer lunch. Okay, thank you. And one other question. What I mentioned earlier, before we did the preliminaries, what I was saying about having all 10 of the jurors go back and talk with each other, you thought that was unconventional. I can do one of 2 things in this case, and I need to know now before you finish up. Do you not want them talking all back there together when they're together as a jury and just wait for them to talk at the end of the case? Or allow them to talk when they're all together as a jury back in the deliberation room?
Let them talk all together.
Okay, all right, that's what I needed to know. Thank you. Go ahead. Thank you.
Judge Coleman.
The flooring need to be replaced, the house need to be fixed from the flood. The Johansson had someone they said that was recommended by the tenants at that time, I believe it was, but they couldn't get to it for 6 weeks. Well, when the emergency services, restoration service, what do you want to call them, they come in, the first thing they did was rip out the floor. Now you have raw floors. Then there was a report made about asbestos residue on the floors from the old tile. So it was a concern that they get the house fixed immediately because they didn't want to move out and leave all their things. They also didn't want to move to storage, which the restoration company had a storage place in Chandler. Well, it's clear across the valley. Anything gets moved is going to get damaged. I can understand their point. When all the their options failed, they asked us if we could fix the house. We did. We didn't want to at first. We told them no. Not what we were there for. We were there to semi-retire, not do construction work. Eventually, we conceded and said, yes, we'd do it. They liked the work. It eventually led into a business arrangement and partnership in an LLC. But they're going to tell you now because things have changed and, you don't want to embarrass an attorney who turned on you, which is what he did. So anyway, we did the work.
Objection, Your Honor. Move to strike.
Sustained.
We moved forward in business together. And as they were getting older, they wanted to get out of the rental business. That's cool. We'll say that's fine. We don't care to do the work either. So they're going to sell the homes and purchase a franchise. I think it was talking about a Subway or something like that. Not sure. They weren't sure. So the homes were sold. They collected the money. In the process, Mr. Johansson decided to hire Mr. Easton for another issue outside, which was his trustee on his sister-in-law and his deceased brother's trust. Mr. Johansson hired Mr. Easton to handle that situation, and Mr. Easton did. He suggested along the line to close the trust and award the proceeds of the only asset that trust had to himself. The problem with that is his sister-in-law had a son named Brad Adams. Brad Adams and Creekside Continuing Care, which is where Joyce lived at, the woman who owned the trust, and they took the money, made a complaint, criminal complaint, launched a criminal investigation against Gary. Mr. Easton injected himself in that one, though he wasn't retained, but he did get involved in it. And there's documentation evidence that proves this, that has been submitted as evidence that could be considered. Through all this, when nothing else worked to get the complaint from Adult Protective Services dismissed, this complaint, this lawsuit was filed, submitted to Washington State. It didn't get dismissed at first. It wasn't served. That's why the late service on this. It was filed September 6th and wasn't served till October 19th claim. Okay, it wasn't we were there dating service, like he may tell you. No way. He did it intentionally waiting for an answer from Washington State if it's going to dismiss the criminal investigation. It didn't until he had it served. And then 11 days later, that criminal investigation was dismissed. That's where we are. Now, did we do anything wrong? No. Did we get targeted by an attorney I hired? Yes. And that's what can be proven. Thank you for your time, ladies and gentlemen.
Thank you. My apologies for today's delay. I will not keep you over on the other days. Because we're leaving late for lunch, you're not required to return until 1:55. Now, remember the admonition, but I've had the opportunity to talk with the parties. We've agreed that as juries, you are permitted to discuss the evidence amongst yourselves in the jury room during the recesses from the trial when all jurors are present, as long as you reserve judgment about the outcome of the case until your final deliberations. Your privilege of discussing the evidence amongst yourselves during the recesses may be limited or prohibited by the court, but not at this time. There's no evidence that's been presented to you. So again, remember, you can't talk to everyone outside of the court, your family members, your friends, about the case. But when you're all together in the jury room, after evidence has been presented, you can discuss the case as it goes along amongst yourselves. So as far as everybody else goes today, if you want to call your family, let them know that you're on a jury until February 1st and the times of the trial, you're welcome to do so. Enjoy your lunch break. I will see everyone back here at 1:55. We will end the case today at 4:30. Thank you.
All rise.
Thank you. Please be seated. Let the record reflect the jurors are excused. I'm in the presence of the parties as well as counsel. All right. Thank you all for your opening statements. We will break for recess until 1:55. Is there anything additional for the record at this time? All right. Thank you. Have a good lunch. See you back at 1:55.
Thank you.
All rise.
What's our access day going to be? Because we don't have.
Do you need to get to, if you need to be in here, I can make someone available.
I just normally do, I usually,
Do you wish to stay here and review your items?
yes.
Okay, then what, if that's the case, then we're going to keep the FTR on. So then it's, people will be in and out, but you'll be recorded.
Okay.
So be careful with your statements if that's what you intend to do.
Okay, thank you.
Thank you.
Yeah, I used to do Garrett. I think this until 5 o'clock.
Okay.
Doesn't he lie? She's taking your exhibits. She's taking your exhibits.
I think she's just securing exhibits if she's doing anything.
She's moving you.
Mr. Easton, I certainly do apologize, but we do have a courtroom clear at the lunch hour because that gives a chance for all staff to be able to take lunch. Otherwise, I apologize, if
That's
we have
okay.
it all in here, then the staff doesn't get the lunch. And so our exhibits will go back and forth and back and forth. So my apologies on that.
Okay.
So sorry, guys, I'm getting ready to lock up. The commissioners didn't realize.
You would inside the door, can I?
Yeah, we'll just go outside the
None
door.
of the staff can go either, so you're welcome to, I'm gonna lock up right now. Okay, so again, my apologies, I know the commissioner said, no, go ahead, but I'm like, oh no, we wouldn't be, none of our staff will
worries.
be able to take lunch, so my apologies on that, but thank you all so much for understanding.
No worries, we're good. Did you get your coat? Okay. That will work.
I don't know if they have a little section downstairs anymore, but you're welcome to kind of hang here or,
Let me know. Like right now, technically this room is live on the live feed, and that's all good, but if you just do it, kills all the audio from the room.
Perfect.
I think that's our best. So we keep running, but you gotta remember, otherwise without that, your live feed has no audio. So I guess we can.
We can. Said one thing. So you know, she says first. It's fine, you know.
How's it going otherwise?
I'll
just take it just in case.
Can't miss that, right?
Also, I had a question. Is the recorder supposed to be muted or as it is?
Uh,
Because at one point, it picked up a random sound and turned blue, but I didn't know where it came from, so
Yeah, it should, yeah, the recorder should be.
just leave it
Yeah,
as
just
is.
leave it
Okay,
as is.
cool.
That's a weird one for it to come back. And of course, this one's a little light up.
Yeah, I knew
Or-
that one. And this, randomly, it was just like a beep, and then it.
Oh. At some point, we did have the button.
Is that what that was? Okay. Yeah.
So someone-
No, I thought she did accidentally touch it, and I didn't know if that was.
It was during a bench conference.
Yeah.
It's all good. And of course, right now, we're still at TR, so it's something too
Okay. Cool.
nice.
Thank you.
You made it through the morning.
Did you go turn everything offline?
I have everything's muted, but we're still.
We're still in a
recording.
live feed.
Yeah.
Yeah, did Ron let you know?
Yeah, he said just to mute it.
Mute everything,
So
okay.
there's no sound.
Perfect.
So it'll still be recording because if we keep turning things off and on, it might not work again.
Perfect, so I locked up.
Okay. Should we wanna?
everything goes and goes and goes. Everything she said was needed in here.
Not during the trial, though, right?
No, just right now.
Yeah, okay.
Because she didn't turn anything off. I just did the lights, but I can turn them back on.
That was good.
Kind of basket. There's forms on.
What's that?
We gotta find a basket to put our question forms on. Or in. When I
Oh,
put 'em over
gotcha,
there.
yeah.